Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
They bring the jury.
Hello, everybody. Happy Thursday. We're back. Sorry, we're a few minutes late. Llama's basement flooded overnight from all of the rain. So I had to take some pictures and video, call my mom, and be like, Mom, will you talk to the insurance guy for me? Even though I'm 40 years old, please and thank you. I got a show to do because I'm a star. Just kidding. I did not say that. Oh, no, but it's not great. It's not great, friends, at all. Ohio has been through it with the storms this week. Lost power, now flooded basement. It's just like they don't want us to stream anymore, I think is what it is. But
Well,
okay.
you're
Can't hold
practically a
me
New
down.
Orleans. You're practically a New Orleanian now.
Oh, okay. Oh, look at that. Dual citizenship.
No
right there.
power, and you're flooded.
Yeah, the Louisiana way. Oh, hello. Good morning to you, RJ. Hope you're doing well today. Bill, good morning to you, babes. Hope you're doing well. Angie, hello, hello, hello. Good morning to you, babes. Mary Smith, hello, good morning. Love seeing you guys all again. Water is not my friend, Lady in Gray. It's not. And it wasn't just from the rain. So, like, since I live in the city, it's like, so we have three big rivers in my city that are completely flooded over, which then floods our sewer system, which then backs up into our basements. And now there's 3 to 4 inches of water and maybe sewage in my basement. So it's so great.
It's
so
the
great.
sewage part.
Yeah, it doesn't smell great. I'll let you know that. It's not great. So I guess that's what our weekend will be doing, which is cleaning out the basement. Yay. Love it.
Well, sometimes you need a little motivation to do it.
That's true.
Nature was just giving you a reason.
Girl, that thing's need being cleaned
I
out.
don't need that
years.
kind of motivation.
Just be like, just rent one of those big ass dumpsters and just put it out of the house. Let's just throw everything away. We don't need most of it anyway. But yeah, so that'll be my fun weekend. Super excited about that. Hello, 80s. Hope you're doing well today. Happy to see you here. Oh, you've tried 2 new Alani flavors in a week. We are terrible influences. Which ones, Bill Marie?
No, we're great influencers, Alani.
It's true.
If you're
Alani.
listening,
I buy like 2 cases of
I
you
know
from you twice a month.
I know you're not listening, but
Hello, half-ass fashion. Hope you're doing well today. Well, I'm excited because we're getting back into Laura Owens because we were covering a bunch of different things right now. And today we're going to be reading David Gingras's appeal for the Owens v. Echard case. So it's not brand new news. Apparently, somebody wanted to leave a comment on our other videos that I forgot what were we talking about? BAM or something. And they were like, that's old news. And we're like, okay. And they're like, you should just be a history channel. And we're like, sir, shut up. Who even are you? You don't even have a YouTube channel. Be quiet.
sorry,
but
I didn't know it had an expiration date.
I guess if it doesn't happen in 24 hours, you're not allowed to stream or talk about it. Thanks to whoever left us that dumbass comment, because that's exactly
I
what it
did
was.
not get the memo on that.
No.
Somebody ought to tell Netflix about that. They're not allowed to make any more documentaries.
Right? Old news says this guy on
Old news,
YouTube.
sir.
You can't do it. Yeah, Lady in Gray says the witches brew's good. She said it was like a green sour Jolly Rancher. I've not had Orange Kiss or Hawaiian shaved ice. Oh,
You
but I
had
can't.
me a Jolly Rancher.
Hmm?
She had
That's
me a
what Lady.
Jolly
Now my niece said she hated it, but what does she know? She's 18. She doesn't know anything about anything. Just kidding. She's not watching, but in case she is. She's like, I don't care what Aunt Todd's doing with her life. I'm like, yeah, I know, me either. Hi, Echoes. Happy Thursday. I didn't know you had a show last night. So I'm gonna go watch you Well, maybe today. I don't know. I have a pretty busy day now. I think about it, but
Now that
I
you
didn't.
have it
I was.
playing in the background while you clean your basement.
Oh yeah, that's true. I could do that. Yeah. Yeah. I didn't know you had a show listening because it was a Wednesday, and then I woke up this morning and did my perusing of the YouTubes, and it was like Echoes had a stream last night, and I was like, on a Wednesday, Rue, on a Wednesday, but yeah, he did. So gonna have to go do that. Oh, that reminds me, I forgot to pull up the Gingras 911 call because that's what we're gonna listen to first. I know some body cam came out as well, but we're gonna save that for our timeline because it's not a super big deal. Okay, your cat has opinions.
She always has opinions.
No. So let me pull that.
Mostly she's like, "Hey, mom is sitting and she's not going to move, so now I can harass her."
Oh, nice. I have not tried either of those. All right. So to start us off with first, so just recently, they finally released the 911 call that Gingras made at the Owens v. Echard June 10th hearing slash trial, whatever you want to call it. It doesn't really matter. Um, remember he like calls the cops beforehand and is like, Mike Maraschini's here. You should arrest him for breaking a protective order. And we were just like, what? And it was kind of weird that like they hadn't released that yet. There was another one that they recorded something, and maybe it was just that one. And we were just like, where's it been? But they do things on time. So let's listen to Gingras for some reason calling 911 while at a courthouse surrounded by law enforcement. Um, to get Mike Maricini arrested because it's very serious. His client is very serious and very scared. Um, why do my notifications suck? I miss it too. No, it's a very big problem on YouTube right now. It doesn't notify me of anything. It doesn't notify other people. So it's not just you. I thought they fixed it for one day and they must have been like, we can't have everybody on YouTube being happy. Let's take it back. I don't know if that's what happened, but oh, you guys counted 5 lies over there? Oh, interesting. Hello, Bruce. Good morning to you, good sir. Ahoy, ahoy. All right. Well, let's get into listening to this. It's not very long. It's only like 7 minutes. And we'll be listening to this from Schnitzel Ninja's channel, which nice to see her. Did you know she did an update last week too? I've been so out of the loop ever since I lost power. I don't know what day it is. I can't seem to catch up on anything. And she had like a half-hour video, like with her updating all the case stuff. And I was like, "Ah, what? Again, I blame YouTube for not putting out notifications. All right, so let's take a listen here, shall we? And see what David has to say. What stupid shit is David going to say? Story of my life. All right.
Phoenix 911, what is the address of your emergency?
Hi, I'm at the Superior Court on 40th Street and Union Hills in Phoenix. I can get you the address in a minute, but I assume you can look that up.
Okay.
I can't
What's
believe you
going
called
on?
911.
I'm an attorney, and I'm here with a client who has a domestic violence restraining order against an individual. The individual is here in violation of the order. My client is scared to death. He's been making threats towards her, and we'd like someone to come out and enforce the court's order.
What threats has he made to you, David? Besides not allowing you to call him or talk to him, what threats? Stop. Already with the nonsense, David. And, here he is using his authority as a lawyer. So therefore, you probably should take this seriously because I'm an attorney. Why would I be dramatic or, anything like that? Oh, she's scared to death. Oh my God. The drama already.
8380 North 40th Street, sound right?
Yes.
On Superior Court. And do you know the client's name?
Yes.
Do you know the client's name? I hope so. Oh, it's probably.
And her birthday, do you know?
You're so spontaneous.
Okay. Do you know if this has been served, this order?
It has, absolutely, it's been served.
So is he supposed to be there or no?
He is not supposed to be here. He does not have permission to be here.
Okay.
But he does.
That subpoena
He
says
does.
otherwise.
The subpoena says otherwise. And didn't the judge, if I remember right, didn't Judge Mata literally tell him that morning, it's fine. All right.
Yeah.
We have security, we have bailiffs. I'm pretty sure she
Right.
told him that morning. But sure, he doesn't have permission to be here. He doesn't have Laura's permission. And that is the only permission that matters in the whole wide world. Is what does Laura think and feel all of the time? Oh my gosh. Preposterous.
Correct. Party.
There we go. What did I
The
press?
restrained party is a different individual, and I have his information here.
Can you please give me his name?
Yes.
And doesn't, at this time, correct me if I'm wrong, Chad, because it's been a while, my brain is on overload. Don't all three of them have restraining orders at this point? Mike, Clayton, and Greg, right? I think so. So they're only calling on Mike, though. 'Cause he's scared. He's not scared.
Last name.
Or did he call on all three of them?
No, he's
It's just
calling
Mike,
on
right?
Birthday?
Date of birth.
Ridiculous.
Okay. Where's he at right now?
Oh, yeah, Laura had
He's
one
in the
too.
hallway. He's
Right.
about 20 feet away. My client's locked in a room because we had court security put her there. She's absolutely scared to death. But the guy's here in the courthouse somewhere.
Do you happen to know the case number?
I do. I don't have it in front of me. We're here in front of Judge I have a case number here, if you're ready. This is not the case number for the restraining order. The restraining order was issued out of California. It doesn't make any difference.
Yeah.
I have the case. I have both. We're here on a paternity matter that this
That's
too.
true.
He's not a party to this restraining or to this matter, but he's there.
Oh, this one's just for Mike.
He's
Thank
there.
you, Bruce.
He's here.
Okay. Sorry.
He's claiming to be a witness, but he does not have court permission to be here.
He does,
Not from the
though.
California court.
Well,
So he's not involved in court case today, right?
He's trying to be involved, but he's not allowed to be. The court order does not
He
allow
has a
for any
subpoena.
contact whatsoever, including in court appearance.
Sorry.
I'm going to have to go re-up my coffee.
So his ID would be out of California?
Correct.
Okay.
And I have a copy of the order in my hand right here as well. So
Oh, a copy printed out and everything so quickly? What are the odds?
And is he white, black, Hispanic, Native?
he's white, about 6'4".
And how, like thin, medium, heavy built?
His weight is listed as 220 pounds, 6'4", feet thin, I guess.
Do you remember
Brown
what
hair,
color shirt he had on?
I don't. I only saw him from a distance, and it was brief. But my client saw him and immediately sort of ran into hide.
Has he ever been known to carry weapons, as far as you know, with your client?
Oh my goodness.
I don't believe so.
Okay.
I think he can't. I think the restraining order prevents him from. Oh, no, it does say no weapons, but I'm not aware of any weapons at this time. He came
It's a
through court
courthouse.
security, so that shouldn't be an issue.
Exactly.
All right.
Oh
Do you
my
know what it was
goodness.
for, or what kind of threats he was making today?
Yeah.
Just to be here, just to terrorize her, I guess. He's not allowed to have any contact with her. It's not an order that just says no threats. It's an order that says no contact whatsoever.
Oh,
Okay.
but you said earlier that he was saying threats, but okay, so now he's not. Just his mere existence is a threat to humanity. And very scary. Okay. All right. Just
Do you
to
know
be
where he is
here.
now?
I don't. He should be at or near Judge Mata's courtroom. I think it's courtroom 101, possibly.
Okay.
I would
He's
think
in the north side of the building. He's within, the order requires him to stay 100 yards away, and he's certainly within that.
Okay, so I have a lieutenant asking if there's any way you can go up to the security guards there, because this is an MCSO jurisdiction. Do you
Like,
know
yeah, but they didn't want to
that?
do
Is
anything.
there any way they
I
could
just
be a whole-
talked to the sergeant. I just talked to the sergeant here, and he said calling 911 is the right protocol. So I don't know. I mean, the court security here, I believe, are sheriff's deputies, but I could be wrong. But he said
I believe that they didn't say you should call 911. You said, "Well, I am gonna call 911," and they were like, "All right, whatever. I don't know what to tell you," if I remember right. Oh, yeah, Mike was on the verge of they're such assholes, man. Like, literally nothing is happening, and he's blowing it up out of proportion, and, he is such a liar.
I'd call Phoenix PD because we're in the city of Phoenix.
Oh,
Straight
okay. What was your name?
My name is.
Last name?
Who even are you?
No, I believe didn't we read something about that sergeant and what he said about it? He was just like, "We're here, nothing's gonna happen. Like, you
Are you
can
still there
call
with
if you
the
want." But
MCSO? If you could just confirm that with them, because they're driving right now, but I just want to make sure that this is accurate.
Yeah. Hang on a second. I'm just looking for somebody. There's a sergeant here I was just talking to. I don't know where he went. I'm literally standing at court security.
Okay. Can you just ask them if this is MCSO jurisdiction, if I need to bring them on?
Hey, there's a sheriff's deputy right here. Sir, I'm on the phone with 911 talking to Phoenix PD. We have a guy here who's violating a restraining order, and she's asking whether or not
goodness.
MCSO can help or whether the Phoenix PD. No, you're shaking your head. Yeah, it's Switzerland. Okay. Sheriff's knows the Phoenix PD matter.
It is. Okay. All right.
Yep.
Oh, Phoenix.
All right.
You?
One sec.
I know, poor Bruce.
I'm sorry, you said which courthouse was it?
40th Street and Union Hills.
No, the
Several.
courtroom. Sorry, that he's going to be.
Apparently, there are several courthouses in Phoenix, and it's very
Oh, wow.
confusing.
Well,
I
I
learned
guess
that,
I
and I was
just
like,
don't
"That's
live in a
weird."
very. I don't live in a very big city.
We have
so it's
we
like
have
one.
two. We have two right
have-
next to each other.
We have a city court here, and then we have the parish court, in the next city over.
We have the municipal court, which is like misdemeanors, other kinds of law. I take that back. I guess we technically have 3, but the one is like juvenile and like domestic, really like custody, that sort of thing. And then we have municipal, which is like misdemeanors, environmental, rental, all of those kind of laws. And then we have the common pleas, which is like felonies and civil lawsuits and
Wait,
things like
in
that.
3 separate buildings?
Yes, but they're all right beside each other.
Okay, see, no, we don't. We little city, I guess. We have one courthouse here, and not even in my city. It's in the next city over.
Mm.
And then the parish courthouse where everything is. Like everything is. Family court, felony court, like traffic court is all in the big courthouse.
Hi, Jennifer. Good morning. Says, I wonder if Corey Security could do an interview. They might not be able to speak about the case specifically, but does this happen a lot? A lawyer trying to get a witness against his client arrested? I'm going to go with it does not happen a lot. I don't know if they would be able to speak about that. I mean, I guess it wouldn't hurt to ask, but their answer is probably going to be no.
Oh, because
But
I mean, this is a civil trial. I don't know. Is that witness tampering?
technically, it
A
would
witness
be.
intimidation?
Yeah. I mean, I don't think it really matters if it's criminal or civil. It's still like against the law.
I think it's a little bit more
Here?
dire.
I believe it's courtroom 101. It's on the north side of the courthouse. There's not that many. There's only like 2 or 3 courtrooms in there.
That's it. Ours are like also like a multi-level. Like, they're huge.
Okay, all right. Well, then they're coming in right now. David, if you could just step outside and meet the officers.
I will do that right now.
Okay.
Okay, thank you very much. Thank
All
you.
right, thank you. Bye.
Okay, well, that was a waste of time. Schnitzel Ninja. Thank you, Schnitzel Ninja, for letting us share that today. We appreciate it. Oh, we're going to hear it again. Well, that was stupid. That was definitely as dumb as I thought it was going to be. Way to go, David. That was unnecessary and uncalled for and a waste of resources. Did you hear him? Ugh. She was so scared. She locked herself in her room. Stop.
I mean, she could have been more dramatic and locked herself like in a utility closet or something.
That's probably what she did. But I like how he was like, "Oh, I have it right here," because he went ahead and brought it to court with him. Because at this
What
point, he
rooms
had
are you allowed to just lock yourself in a courthouse?
ours have like lawyer rooms where like a client and their lawyer can like go, it's a very small room. So maybe
Sure,
that.
but do you just like walk into a random room and shut yourself in? Like you would think that they are like held for people or you have like appointments to use them. You're like,
Yeah, I don't.
sorry, I'm in here hiding. Go find another one.
That's not really how it is here, but we have them anyway. So, hi, Toadette. Good afternoon. I c- I cannot imagine trying to reach 911 half-ass, and then it's just Gingras on the phone being like, they're so scared, even though there are literally law enforcement everywhere who deal like with court shenanigans on a daily basis because court shenanigans happen a lot. Maybe not all of the time, but they're not unknown, right? People get going to court's very emotional. It doesn't really matter what you're going for. Some more emotional than others, right? And it can cause people to react in ways that are probably not very appropriate.
Mm.
So, like, they've had to deal with this stuff before. That's why they probably didn't take him very seriously. Like, sir, are you serious? Like, we have way worse people coming in here, but okay. Oh, the North Courthouse is not very big. There's not an upstairs. Why don't they just have one big place like the rest of us? Arizona's so weird. Ah, jeez. Anyway, all right. That's interesting. Okay, so we have this long ass appeal because, of course, David wrote it. So, to none of our surprise, it's a bazillion pages long. And
Did he
we're
ask
gonna
for a bazillion more pages to add to it?
not quite, not that I know of. Maybe. I don't know. Um, but it's also large print, so which I do appreciate. Um, so we're gonna see what we get through today. And then whatever it is, we'll finish up tomorrow. Then on our Laura Owens timeline, we got a whole bunch of David makes YouTube videos. We're not going to watch the videos, but I do have all the transcripts. So we'll read the transcripts to those. They're just as bad as you think they would be. And we got some Laura blogs, if I remember right. Then next week, we're wrapping up 2024. Can you believe it? Yay, us. We're doing it. And you all know what happens in 2025. It's body cam time. So we finally get to actually cover the felony case in all of this. Now, knowing our luck, I should probably take that damn plea deal at the end of the month and ruin all of my plans. But either way, you all will be very excited to see Buff and I react in real time for the first time with the body cams because neither one of us, we've been good little Llama and Buffies and have not watched them. So to save it for you guys. So Maricopa County is huge. It's like half the entire state, really. How many people they have living in Maricopa County? We have like 1 million. I think 1.2 million in our county. But we need to make Gingras and Low hand puppets for these things. I want hand puppets so bad. Buffy told me no. Hello, Don. Welcome in. Good to see you.
If you're wondering why the chat over in True Crime and Wine Time is very empty, most everybody's chatting over on the new Couch Court with Llama channel. So if you haven't already gone over there and subscribed and joined over there, most of everybody is chatting over there. The link is pinned in the chat in True Crime and Wine Time. And we had a nifty little QR code somewhere for the
Oh, that's right.
screen if you need it. But that's where most everything is going to end up eventually.
That's right.
Is
We're
over on
very
the new
close.
channel.
We're very close to 500 subs. All right. So that way we can get memberships over there, super chats, all the fun emojis that members can use. So please go subscribe, hit the notification bell, even if it doesn't work half the time. Do it anyway for at Couch Court with Llama. We're also covering bricks and minifigs. We've been watching the police body cam videos. We are deep into one of 4 of Karen Reed's civil trials. We're doing a lot over there, so don't miss that. All right, so let's. Oh, thank you. Getting nice compliments about our hair. You guys are so nice. Make some ladies feel special.
I know. Thank you so much.
Everybody get their drinks ready because I'm sure Rule 26 is going to come up a bazillion times because it's David. And I guess we'll see. We'll see how it goes.
Every time it comes up in the Karen Reed hearings that we were watching, I'm like, oh God, we're going to be haunted forever by Rule 26.
And the safe harbor.
I'm telling you, I heard it and it just made me go, oh, I'm happy. I have PTSD now.
I was going to say, we all do. We all should sue David. Just kidding. But maybe. All right. So let's get into this appeal. So introduction. Oh, by the way, he filed this. I forgot to say where we are on the timeline. I want to see November. Hold on. I lost my cheat sheet over here. Outline for today. Oh, November 14th, 2024. So that's how close we are to wrapping up 2024. And I'm so excited. It's been like months we've been stuck here. What happens? Good morning, say cheese. Hope you're doing well today, babes. All right. So this case presents some bizarre, interesting, frightening, and salacious facts. Oh my goodness. Already. First sentence. You remember when he first came in, he was like, this is just a really simple case. I don't understand why everybody's making it so complicated. It's not that big of a deal, but he's going to tell you otherwise. The story involves sex, celebrity, even an alleged fake pregnancy. The cast includes an inexperienced trial judge who apparently broke the law to ensure a Pyrrhic victory for a famous litigant from a popular TV show. Oh, so now Clayton's famous. Not arguably famous, but like famous. Okay. At the end of the day, the strange facts of this case are almost irrelevant to the court's task, answering a very simple yes or no question. Do the rules of procedure matter? Or can the rules be casually tossed aside when they require an undesirable result? David, this is not your blog. it's just as if this is his blog. He's writing
all
this
of his motions are blogs.
But I'm going to start it off with a question, an easy one that I'll say, but then I'm going to take 70 pages to talk about it. What do you want, Keita? Go lay down, baby. This rhetorical question answers itself. Of course, the rules adopted by the Arizona Supreme Court matter. Like all other statutes and regulations, procedural rules carry the full force of law. All judges, all lawyers, and all litigants must follow them, whether they agree with the rules or not. Oh, yay. All of the rules. Love this for us. It is undisputed. What? Oh, it is undisputed that did not happen here. The trial court ignored one of the clearest and arguably the single most important rule in all of civil litigation, the safe harbor provision of Family Law Rule 26. Drink, everybody. The Family Court variant of Civil Procedure Rule 11. We know a lot about that too, covering Karen Reed. They file the 9Cs or whatever all the time. You haven't seen them, but I have since I've categorized everything. There's a certificate always, all of those things. And I was like, damn it, David. I know about this because of you. Rather than applying the safe harbor as the law requires, the trial court transformed it into the proverbial screen door on a submarine, a pointless, useless nullity. Okay. That's very descriptive. It's like a screen door on a submarine. I've never heard that before. Have you guys?
Well, you're definitely not from the South.
No.
Yeah.
Oh,
Yes.
do you guys say that? Oh, I've never I don't think I've
We
ever
say
heard that.
we say all kinds of stupid sayings down here that you would probably be like, really?
Burn the calendar, Dawn. Burn it. Just kidding. Um, when lawyers confuse their blogs with court motions, it's time to pack up the law degree and go find a beach. Y'all, if you like wild and exciting court documents, you're gonna want to watch and catch up on a civil retrial with us because they get sassy. They are so dramatic. It's
And
amazing.
shady, and I love it. I'm sorry. I know we have our issues with Gingras, but he is so entertaining.
I don't think I need to be saying more Southern phrases. I already said one out of the blue the other night, and I was like, oh my God, what is happening to me? I don't like it. The obviousness of this legal error is surpassed only by the ease with which this court may correct it. By reversing the lower court's judgment and remanding this case with instructions to dismiss the action with prejudice. Of course, this appeal raises other arguments and issues, but the court need not reach or decide any of them. But I'm going to write about them anyway. But don't worry about it. Don't focus on them. The trial court's error of law on the first point is fully dispositive of this entire appeal. Okay. The statement of facts against this case. All right, we're going to do our best, friends. Most points in this appeal involve legal errors, which are subject to de novo review. Although Laura disputes many of the trial court's factual findings, she recognizes this court will generally defer to the trial court's factual findings, but review de novo all legal conclusions. All right, so they're going to go back and they're going to read stuff. Okay. I do love a sassy footnote too, Mary. Dumber in a sack of hair. I've never heard that one, RJ. Oh, I like that. Marilyn, hello. Good morning to you, babes. Hope you're doing well today. Yes, 73 pages. Say cheese. Because, of course,
He's got a lot to say.
a lot. There are no attachments. I hate to spoil for you. There are none. It is this. Hello, Dan Montana. Hope you're doing well today. Oh, wow. Interesting. Okay. Thus, plentiful and egregious factual mistakes notwithstanding, factual errors are not the primary focus here. Okay. With those standards in mind, Laura offers the following background facts for context. Okay, great. Laura's pregnancy claim, May 2023. No, May 2023. Yeah, that was right. Sorry. In her establishment petition and later in her trial testimony, petitioner appellate Laura Owens claimed that on May 20th, 2023, she had a brief one-night sexual encounter with respondent appellee Clayton Echard. 11 days later, Laura learned she was pregnant by taking a home pregnancy test, or HPT, because I guess shorten it. Laura sought medical confirmation of the pregnancy the next day at a Banner urgent care facility in Scottsdale. The pregnancy test at Banner Urgent Care was positive. On June 17th, 2023, Clayton invited Laura to his home in Scottsdale to discuss the situation. He's still in Arizona, isn't he, Clayton? Is he still living there? I think he is. Just wondered.
He's got the Airbnb over there for sure.
Okay. I don't think he's in Scottsdale anymore. I feel like somebody said he's now in like the Phoenix area, but it's been a while. The pregnancy test at Banner Urgent Care was positive. Now, on June 17th, I already read that. I'm so sorry, guys. When Laura arrived, Clayton, doubtful of Laura's pregnancy claim, surprised her with a home pregnancy test, which he insisted she take immediately in front of him. Laura took the test Clayton provided, and it was positive. Both parties agree the test was positive. Okay. Oh, this is going to be a pain in the ass to read. Clayton later confirmed seeing the positive test in an email entitled Something to Consider, which he sent to Laura a few days later on June 21st, 2023. In that email, Clayton made several admissions about the pregnancy. Even after seeing a positive pregnancy test, I still had doubts in my head. Something was telling me to look deeper into things. So I did, and came up with a theory that could potentially be realistic. Considering you only performed oral sex on me and no vaginal penetration occurred, don't forget the dry humping and finger banging, the chances of you being pregnant seem considerably low. Although, again, maybe rubbing up against one another allowed a sperm to make its way inside of you, but it's a very low probability. Nonetheless, it is one. Now, Laura and Clayton discussed the situation over the next several weeks, but could not agree what to do. After another positive HPT home pregnancy test on August 1st, Laura filed her establishment petition later the same day because it makes sense. She did that. Ugh. Ugh. Oh, you made it to your first live. Congratulations, Jen. I love when people get to do that. I love it. Oh, thank you. Well, I'm glad we could be there for you. Love from across the pond to you, Jen. You are welcome here anytime. Scottsdale is just a suburb of Phoenix. And hello, Razzmatazz. Happy to see you. Yeah, that's true. That is true. Let's see. After 2 months of unsuccessful private discussions and multiple positive pregnancy tests, on August 1st, 2023, Laura filed a petition to establish paternity. And on August 21st, 2023, Clayton filed a response denying paternity. From the inception of the case and for months to follow, both parties were pro se. In September 2023, Laura and Clayton agreed to submit samples for DNA testing through a company called Ravgen. A Ravgen representative later indicated the tests were inconclusive because there was little to no fetal DNA. Thus, there was insufficient genetic material to establish or exclude Clayton as the father within the 95% certainty requirement. Well, I think it was pretty clear why, as I learned from this case, that once you have the baby, it's still there, I guess. So that's interesting. Bad news arrived a few weeks later. Okay. On September 16th, 2023, Laura had a blood test which showed her HCG pregnancy hormone levels were 102. Although this test confirmed Laura was still technically pregnant, the level of 102 was far lower than normal for a healthy pregnancy at that stage. This indicated Laura had either miscarried or that a miscarriage was inevitable. That means things have already happened. But don't worry, she didn't show any signs of a miscarriage. There's no bleeding, there's no pain, there was nothing. Apparently, she had, according to her, the easiest, cleanest miscarriage one could possibly have with twins. Doesn't even make any sense. On November 14th, Laura saw a medical provider at MomDoc, an OB/GYN facility. At that time, Laura was given 2 pregnancy tests, both of which were negative, confirming her pregnancy had failed and she was no longer pregnant as of that date. After learning of the miscarriage in mid-November, Laura, who like Clayton remained pro se, filed nothing further in the case. She pursued no discovery and otherwise had no case-related contact with Clayton. Is he going to say that because she didn't know how? Because that's not true.
No, he's saying it's because, there was nothing to keep going for. She lost the babies.
Well, he did have an argument that she didn't know how to file dismissal papers because she doesn't have a lawyer. She's stupid. It was one of those where you like insults her, and I enjoy that. Right. It's wild. It's wild. Oh gosh. This lady's. Hi, Jill. Happy to see you. Hope you're doing well today, babe. I know it's been a while, huh? Where was I? So due to inactivity on December 4th, 2023, court administration notified the parties that action was scheduled for dismissal. After receiving the notice of impending dismissal, Laura filed nothing further and took no action to keep the case active. However, before the case was dismissed, Clayton retained counsel Greg Woodnick, Esquire, who appeared and immediately filed pleadings seeking to avoid dismissal. You want to read this for a quick second? I have to go check something in my house.
Okay. First, on December 12th, 2023, Mr. Woodnick filed a motion for leave to amend Clayton's response to the original petition. Next, on December 13th, Mr. Woodnick filed an expedited motion to extend the dismissal date and a request for evidentiary hearing. Just days later, on December 22nd, 2023, Laura retained counsel of her own. 6 days later, on December 28th, 2023, Laura moved to dismiss her petition with prejudice, explaining petitioner is not now pregnant with respondent's children. Here, there is no paternity or maternity to establish, as petitioner is no longer pregnant. Accordingly, this case must be dismissed. On January 3rd, 2024, after Laura moved to dismiss her petition, Mr. Woodnick filed a motion for sanctions. In this motion, Mr. Woodnick filed in this motion, Mr. Woodnick claimed Laura violated family law rule. Say it with me, guys. What rule did he violate?
Rule 26. Woo!
Very good. Rule 26 by filing the establishment petition.
We are all ready to be lawyers. We are all ready to be lawyers.
I'm gonna make a shirt that says lawyer-ish.
Yes.
I'm I'm not really a lawyer, but I'm lawyer-ish. Okay. Petitioner filed the underlying action for an improper purpose without medical advice to support her claim that she was pregnant and or that she was pregnant by respondent. Petitioner could not have become pregnant from the limited encounter the parties had and therefore premised this entire action on a fiction. Petitioner violated Rule 26B 1-3 in her petition and subsequent filings.
Oh, no.
Oh, no. Motion for sanctions.
Okay. There.
Immediately following the Rule 26 motion, the record becomes a confusing and contradictory mess. To begin, on January 24th, 2024, the trial court issued an order granting Laura's motion to dismiss. In that dismissal order, affirmed for a second time the next day, the court indicated, petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. Emphasis added. On February 2nd, 2024, the trial court issued a new order setting an evidentiary hearing regarding the issue of sanctions and attorney's fees for February 27th, 2024. Shortly before the original hearing date, which was later continued until June 10th, on February 21st, 2024, the court issued a new order denying Laura's motion to dismiss, despite the fact the dismissal motion had previously been granted twice a month earlier.
That's how many times
Twice.
he passed the bar.
The first time.
First time. 2 times.
It's very important that we all know that. Matters then become even more convoluted and confusing.
Why is that, David?
First,
I wonder why.
can't imagine why. It's because
because
we
you're-
don't have an actual timeline and we just keep making shit up as we go along.
What are the odds that it would make it convoluted and confusing? That's wild.
It really shouldn't be that convoluted and confusing. You're pregnant or you're not.
Yeah, you know what makes things convoluted and confusing? Lies. Lots and lots of lies do. That's
Lots
what.
of lies. Yeah.
Mhm.
First, on April 3rd, 2024, Clayton moved to withdraw his Rule 26 motion.
Oh, we
After
going to
more than a month,
salami in like 5 minutes.
right? Well, go ahead and just mix it with vodka. and just toss it back.
I
First,
can't. Llama may
why?
not, because I might have to go pick up not so Lena Llama from the bus stop today if it's raining.
Oh, good.
I haven't checked to see if it's
Goodness.
raining. I probably should. Hopefully not. Otherwise, my basement will never stop being flooded.
Right?
I should
Might be
probably
a-
check that out.
It might be moot. Sorry, I couldn't help myself.
Like it nice.
Matters then become even more convoluted and confusing. First, on April 3rd, 2024, Clayton moved to withdraw his Rule 26 motion after more than a month passed without any decision from the court on that request. On May 10th, 2024, Laura filed a motion for judgment on the pleadings, asking the court to deny Clayton's still pending Rule 26 motion as a matter of law. That motion argued that because Clayton failed to comply with procedural requirements of Rule 26, sanctions were unavailable under Rule 26 or any other authority. Can we do a count of how many times this is in that document?
There's at least 10 already.
It's ridiculous. Okay. That order did not, however, resolve Laura's request for judgment on the pleadings, nor did the court mention Laura's renewed request to dismiss her petition. About 2 weeks later, on May 28th, 2024, the court issued yet another confusing order, explaining that due to a clerical error, the court had intended to issue a ruling on Laura's motion for judgment on the pleadings, but due to this undescribed error, the court's decision was not remitted to the parties. The court discussed various arguments raised by each side in the question. On the question of whether Laura could still be sanctioned, given that Clayton's Rule 26 motion was withdrawn.
Drink.
And I know, right? It's good. It's a good thing this isn't a drinking game, like a real shot game, because holy
It is
crap.
not supposed to rain for the rest of the day, but that means nothing in Ohio. It means nothing.
Welcome to
At
the
all.
South.
Oh, thank you, Fletcher Boy, for the super chat. Says David no longer has the boat, and he tiled his mother's bathroom. The struggle is real. I mean, he's in a predicament from representing this case, because he's still he's taken his possible bar suspension to like the Supreme Court now or something. I don't know.
He's got to have a goal in life.
For later.
He's got to have something to do. This is keeping him occupied and maybe off the internet. I don't know.
I don't think, didn't somebody say? Well, I don't think he was. I don't know. The last couple of weeks have just been a blur from everything. But I feel like he posted something on X with like his cat in space.
Oh, really?
Something like that, I think. I don't know.
So now he's taken to AI?
Maybe. Hello, Peachy Teach. Hope you're doing well today.
You did say you wanted him to do a travel blog with his cat. So maybe he heard you and he was like, here's my cat in space. Let's travel.
I love it.
Space travel.
I will take all of his cat in space pictures.
I mean, like I said, that's better than what he was doing. I mean, sometimes the bar is really, really low, right?
That's non-existent in this one, that's for sure.
Okay. Okay. I got to figure out where I was at.
You were here.
Inexplicably, the court concluded Laura's legal arguments regarding sanctions were, look, I knew it was coming.
Moot. The only one he puts in bold.
I mean, I kind of miss the colors.
I know, me too. I was thinking that.
Therefore, let the record reflect. Look, all caps. The court declines to take further action. He's getting into his groove. He's like putting all the things in. To recap, at the end of May 2024.
Oh my God, do we need a recap?
Rule 26 sanctions motion was withdrawn. The court ruled the issue of sanctions was moot.
Not in bold.
sorry, my brain is just getting like visions of like Gingras next to a cow. It's just moods.
We're gonna have to
And
use
no,
that for a thumbnail.
I'm gonna dress him up in the Chick-fil-A cow costume with the little cardboard sign that says moods.
Yes. Yes, please, and thank you.
And no other motions remained pending.
Oh, man.
Despite this posture, and with nothing left to decide, the court still held an evidentiary hearing on June 10th, 2024. Following a 2-hour hearing on June 18th, 2024, the trial court issued a lengthy 19-page decision, which lengthy, that's lengthy. The
Right.
man who's writing a 73-page appeal and a 40-page motion to extend says the 19-page ruling is lengthy. Got it.
Right. Right. Only he
Okay.
can write novellas for every filing ever. Okay.
Interesting position. Okay, so they wrote a 19-page decision which contained findings on the issues of sanctions, paternity, attorney's fees, and costs. Many of these findings are either directly contrary to the admitted evidence or supported by no evidence of any kind. In the end, the court found Laura acted unreasonably when she initiated litigation without basis or merit. Without an authentic ultrasound, I mean, that's kind of important, right? Like,
Kind of.
that's kind of important.
But don't overthink it. It's about they didn't file the one certificate for safe harbor. All right. That's all that matters. Don't worry about all that.
Never mind the absent baby and the not fake stuff.
No. Not
okay.
important. That's what David said. Don't worry about it. It's about the rules, Buffy. It's about the rules.
I mean, I think the rules explicitly say you have to have merit.
And good faith.
Or at least merit. You have to have something to go to, like actual. Oh, okay. Well, I could go on a tirade about that. Without an authentic ultrasound, sonogram, physical examination, and in conjunction with a belief she passed tissue in July 2023, the court finds the underlying petition premature at best.
Yeah, it's almost like you need, like, to produce something other than peeing on a stick.
Oh, wait, really?
I guess.
In the post-trial, you would think. In the post-trial ruling, the court again recognized Laura's argument that Rule 26 sanctions were inapplicable because Clayton failed to comply with the procedural requirements of Rule 26.
This is 4 times in this one paragraph.
Sir, at this point, I almost think he does it on purpose. I
think
feel
so
like it has to be like on purpose. Like I think he does it like I make thumbnails to purposely just be funny. Like I think he's like, yeah, this they're gonna read this. Let's just like make them say this over and over again.
I think so too. And if we believe it to be true, that's all that really matters. According to him.
It's true. I know. Exactly. It's the way it works, right? My truth is the truth.
Right? Everybody hit the like button if you are not Laura Owens, please and thank you.
My truth is the only truth that matters, guys.
Exactly.
The court further noted a separate problem. Clayton's Rule 26 motion was withdrawn. The question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion?
Okay.
Without allowing any input from the parties, the court held despite the withdrawal of Clayton's motion and ignoring his failure to comply with the requirements of, oh my God, Rule 26, and contrary to its prior order, holding the issue of sanctions was moot. And despite the fact the case had previously been dismissed twice, sanctions could still be awarded sua sponte. This lends credence to the idea that family courts' inherent authority towards sanctions under ARFLP 26 should not be read to be limited by the course of the case or by the litigation strategy pursued by the parties. The power is there by rule and can be used by the court when necessary and appropriate. In addition to awarding sanctions sua sponte under Rule 26, I'm telling you, he's doing this on purpose. There is like, he could literally just say under this rule, I guess. I don't know. I'm not a lawyer. I know you're supposed to be very specific in these things, but I think this is deliberate.
I mean, it's also, he keeps saying the same thing over again, but okay.
Well, also, I do think he like, he's like one of those people that I have to meet a word count. Like, like I got to put in every filler word necessary so this looks meaty.
And we know he doesn't backspace, so it's just
it's true. It's just
full
a
stream of
flight
consciousness. This appeal,
Yeah. It's like, and another thing. The court also concluded Laura knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and cost is appropriate under ARS 25-415 and ARS whatever. All right.
Coming.
It's okay. I'll just go to my other page. It's fine. I don't need you to babysit me.
Oh. But
I've learned that if I'm going to read, I need to have it pulled up on another screen because you're going to.
That's true.
Leave me here to read the dirty stuff and disappear.
I think I read the dirty stuff today.
You did. You did read the dirty stuff. I mean, you even ad-libbed more dirty stuff in there. You needed to be like finger banging and. Although that would have actually been kind of funny to read in his motion.
Oh, yes, Fletcher boy. David should sign everything. Rule 26, all the best. And when we've been reading these Karen Reed emails from the lawyers for the civil trial, how they sign off sometimes is very funny. They'll not sign their name at all, but when they're real pissed at the other attorney, they'll sign it best. And you're just like, ooh, you're being sassy.
Yeah, you can
because the
usually
lawyers
tell
all
when
hate
they're-
each other.
when they're like getting mean with each other, when they have a nice salutation, best.
Mhm.
Have the day you deserve.
It is like his Perry Mason catchphrase. I hate how much I know about this rule now too.
Oh God. Look, we're learning all the cool civil things now. See, aren't you glad we are in civil court now?
Hey, I think it's really helped in covering Karen Reed's civil trials. I'll give him that. I kind of somewhat understand them now, not very well, but it's helped.
See, you could be a teacher, David.
Oh, I didn't say David taught me those things. Whoa, Buffy. I did not say it was because of David I've learned these things. I've learned a lot of how things don't work from David.
I was being sarcastic. I sometimes say it not like when I'm being sarcastic, it's like not. I do say it kind of dry.
Now, anytime I see it, I'm just like, whoa. Uh-oh. No, Rosenberg, because I don't think you were with us yesterday, Stay Cheese, were you? Or maybe it was the day before. Rosenberg and Jim for Colin Albert, attorney, they were going at it in their emails. And when Rosenberg signs best, it means go fuck yourself, by the way. It's what we've interpreted it as. Anyway, sorry.
Yeah, you used to say that at work to mean customers when they're being assholes. I would always tell the meanest, the worst customers, have a great day. And that was my fuck you. In my head, that's what I meant.
Absolutely.
All right. So the court later awarded Clayton's cost and fees in the amount of $149,219.76 in a judgment entered on August 16th, 2024. Post-trial developments. Before the final judgment awarding fees costs was entered, several critical events occurred. Bum, bum, bum.
What happened, David? Tell us.
Oh, I'm going to tell. Oh, he's going to tell you.
Oh, I can't wait.
These developments warrant further discussion. See, I'm going to tell you.
Oh.
As they relate directly to legal arguments presented in this appeal. First, immediately after the trial ended on June 10th, Laura learned several individuals posted videos on social media claiming the trial judge's father, Mr. Harry Howe, personally attended the trial and allegedly spoke with them about the case.
The
because
whore, the
people
shocking
have
whore.
opinions.
Can't
You
handle it.
cease to be able to think for yourself when your daughter becomes a judge.
Right. Say cheese. I think the emails were from Tuesday's stream, by the way. You'll enjoy them. You'll enjoy them. Anyway, sorry.
Okay, among other things, these supporters claimed Mr. Howe told them he discussed the case with his daughter. Honorable. He still called her honorable. Julie Mata, because I figured the way he is that he
This
wouldn't even
bitch,
put that
Julie
there.
Mata.
That's what I would have gone. I mean, I wouldn't have gone with it personally, but it's Gingras. And that she printed out case-related documents for him and said, inter alia, Dad, come here. You've got to see this. Does somebody have this on tape? Like,
Right? Like,
what proof do you have that actually was said?
And I don't, yeah, that doesn't sound okay.
Okay. Sounds like hearsay to me.
Mm-hmm.
Second, and far more concerning, after receiving the court's post-trial ruling, Laura immediately noticed one of the most critical factual findings was not based on any evidence admitted at trial. Rather, the key finding appeared to have been copied from a social media post made by an anonymous third party after the trial concluded.
And it was a calendar date. How else would she have found out if not for social media how calendars work? Clearly. The Honorable Judge Mata has never looked at a calendar or knows how to use a calendar without looking at social media to tell her how, but sure. Okay.
Clearly, she would have never came to that conclusion on her own.
Never.
Specifically, in summarizing the trial testimony of Clayton's medical expert, Dr. Samantha Deans, the court made the following findings. She, Dr. Deans, testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays. When petitioner testified, she sought care on July 2nd, 2023.
Now, never mind that his client lied about all of those things. Don't worry about that, Mr. Appellate judges. How many are there usually? Like 3, I think, at this level. I don't know. But don't worry about my client lying and saying that she went anonymously and unchanged the dates. That's not important. What you need to know is that Judge Mata didn't know how calendars work until she saw it on social media. That's what's important.
It's pretty important.
It's very important.
It's very important. I need to put it in bold and also underline
Otherwise, how will you know, you dumb?
that I'm serious? God, you stupid judges.
Stupid.
The specific finding that Planned Parenthood is not open on Sundays was attributed to the trial testimony of Dr. Deans, but as the trial transcript clearly shows, Dr. Deans said no such thing. Instead, it appears the only basis for court's findings was social media posts published online after the trial concluded.
Which wasn't the social media, was it on social media or was it his blog that somebody said that? I can't remember.
It was
But
on
also,
both, I think.
was it on
There
both?
was something on his blog.
Probably was. It's the only basis that the court could find by reading his blog, obviously. It's ridiculous.
Immediately upon discovering this extremely serious misconduct by the trial judge, Laura filed several pleadings, including a notice of change of judge for cause, supported by an extensive affidavit, because I wrote it, of counsel. Laura also moved to vacate the judgment, moved for a new trial, and moved to amend the judgment. Simultaneously, Laura also reported these matters to the Commission on Judicial Conduct, which opened an investigation, which remains ongoing as of the date of this brief, as of the date this brief was filed.
Right. I mean, of course she did. Of course she went after she goes after her own lawyers all the time. But
I was about to say, like, that's to the shock of no one, right?
To the shock of no one, she reports people for everything.
On July 18th, 2024, despite having no authority to do so while she was subject to a pending notice of change of judge, and before Clayton filed any brief opposing the motion, Judge Mata denied Laura's new trial motion and her request for the other relief. And several days later, after this apparent act of retaliation was reported to the Judicial Conduct Commission as a violation of Commission Rule 14, prohibiting acts of retaliation by a judge.
So they were online all over the place. Okay, sorry.
In response to a complaint to the commission, Judge Mata issued a new order withdrawing her prior order, claiming she was unaware of the notice of change of judge that would suspend the court's authority, even though the notice of change of judge was mentioned on the very first page of the motion for new trial. She just denied. On August 13th, 2024, I do love his little, and I'm just going to editorialize right here after I state the fact. It's like my favorite part. On August 13th, 2024, the presiding family court judge, Honorable Rhonda R. Fisk, denied Laura's notice of change of judge. In her order, Judge Fisk recognized Laura correctly points out that Judge Mata's July 17th ruling contains a factual error. The transcript from June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. Despite this, Judge Fisk concluded the evidence failed to show Judge Mata independently investigated the facts. The court finds Laura relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation and therefore is biased. Despite this, Judge Fisk could not explain and did not explain how Judge Mata could have properly found Planned Parenthood is closed on Sundays. Maybe she called. I don't know.
I mean,
or maybe
again,
she
never
just
mind
knows that it's a government building, right?
And also, like, never mind that, again, your client lied about all of the other things in that that's listed there. There is no anonymous. There is no anything. But don't look at my client lying on the stand.
I can understand why he would wonder why she knew that if you're supposed to just go off of testimony. But I think the whole thing is ridiculous to begin with. And I think she just was like, seriously, though.
That's true. That's true. Fair point. Oh, do I need to scroll down? I'm sorry.
No, I don't. I'm not quite there. I'm just kind of. Okay. So she could not have properly found Planned Parenthood is closed on Sundays since no trial testimony or evidence addressed that issue. Judge Fisk ultimately brushed that concern aside, concluding the question of Planned Parenthood's business hours is of little to no importance. See, that's what I'm saying. Like, it's kind of just dumb because all of it's irrelevant in just based on the other evidence. Like if that wasn't even there, it would have no bearing. Like it doesn't change. There's no weight to it. Like
it's moot. Doesn't matter.
Yeah, right.
Your
It's
client
of
lied too
little
many
to
times on the stand, but they got
right. So
recommended to the DA.
yeah, it's
Oh,
of little or no importance given the rest of the findings in the July 17th ruling. Yeah, we'll put that one word hidden in all the little brackets of there. Okay. After Judge Fisk denied Laura's notice of change of judge, she authorized Judge Amata to rule on any remaining issues. This resulted in the court granting Clayton's request for fees and costs. Are you really mad about that? Like, you didn't think that if you brought all this crap to trial that you weren't going to get assigned, even if he had even if Clayton had won it, you were going to get stuck with all that anyway.
yeah. But they didn't like it.
You can't bring stupid lawsuits and expect to not pay for them. Like, that's literally the name of civil court. He with the most gold wins. It's the golden rule.
I love that.
Anyway, the golden rule. He who has the gold wins.
It's pretty simple.
Anyway, I mean,
except on Sundays.
The rule of. I'm sorry, it's just the rule of civil court.
It's true. Unfortunately, it's very, very true.
Yeah. Okay, so he's mad. She's got to pay money. Okay, and the judgment entered August 19th, 2024, and denying all of Laura's post-trial motions for a second time. There's a reason that you keep getting denied, bro.
I know. What are the odds?
This timely appeal. Go ahead.
Oh, I was just going to ask South Florida Threats. Is this in regards to the Sunday thing? That it was in evidence before? See, I feel like I've seen it before, but then again, there's been so much, it's hard to keep track of. So, all right. So you don't need to read all of that crap. No one cares.
Okay.
All right.
Where statement of issues.
I thought there was only one big one.
But... Got a lot of issues, my friend, but I don't.
Sure does.
Issue 1. As a matter of first impression, when a party files a motion seeking sanctions for an alleged violation of family law rule 26, but that party does not comply with any of the procedural, you are so fixed. Like, he is so fixated. It's ridiculous.
I didn't know this was an issue. Did you? He never talks about it.
Sir, why didn't you bring this up before? This changes
yes,
everything.
Everything. Throw it all out. We had no idea. Without your guidance, we wouldn't even known about this Rule 26 violation. Tell us more. Just kidding, please.
But that party does not comply with any of the procedural requirements of the rule and later withdraws the motion. May the trial court nevertheless award Rule 26 sanctions sua sponte in a manner that wholly ignores the procedural and safe harbor requirements of that rule. And assuming sanctions were unavailable under Rule 26, did the trial court err by sanctioning Laura for a Rule 26 violation using its inherent authority or other law? Issue number 2.
Oh, there's a lot of issues. Of course there is. Of course there is.
We need pictures. Did the trial judge commit structural error entitling Laura to a new trial by conducting an independent investigation into the facts? Issue number 3. Did the trial court err by awarding sanctions under ARS 25-324, blah, blah, blah? Ooh.
Sorry.
When there was no basis for such an award and no motion for sanctions under those statutes were ever filed? Issue number 4.
Is this a rhetorical question? Are these all rhetorical questions? Because
he's pondering. This is him.
One.
He starts all the stories like, hello, good sir. Like he's like narrating a story. Like it's really weird.
Yep. And we're only on page 21 of 73, say cheese. So you know this is going to go well.
Yeah, he's going to ask all these questions, and I bet he's going to answer all of his own questions too.
All right. Well, I guess we don't have to discuss it now. I don't know what y'all are talking about with Echoes, but Echoes, do we need to fight somebody?
Oh, I've been looking
we
for
need
a
to fight
good scrap
somebody?
this week.
We will if you want. We're ready to throw down for you. What do we need to do?
Who-
We're out
I'll
of
say,
the
where are we
loop,
going? Where am I buying a plane ticket to?
apparently. We're bored. All right. So
We're bored. I got
what is
time.
I hate being so out of the loop of everything. Oh, stupid storms. Anyway.
Slide into my DMs, Echoes. All right. So, did the trial court err by awarding legal fees of $150,000 when the alleged misconduct did not cause those fees to be incurred? Issue 5. Is Laura entitled to her attorney's fees and costs on appeal?
Okay. So we only have 5 issues. That's it? Oh, wow. That's impressive.
Oh, but
it's in your
God
first 49.
dang.
I'm going to listen to it today. And then probably expect an email from us. And also big hugs. Whatever's happening.
Are
big
we
hugs.
not allowed to talk about our life struggles on our streams? I'm pretty sure
Somebody will
this
probably
is
leave a
your
comment about it.
It's your channel.
I'm sure somebody will have something to say.
If people really like, I don't know, if y'all actually wanted to hear about my life struggles, I could do a 13-hour stream on that.
Let's just do a 12-hour marathon of group therapy. How about that?
Yeah,
10 pages per issue. I think so. I think that's what's about to happen. Say, geez, I think that's exactly what
I was gonna say, oh, that's all the issues. I was like, yeah, but he's gonna talk about every issue at length.
Yes.
Oh Lord. Okay. Argument. Clayton's failure to comply with the safe harbor requirements of Rule 26 precluded sua sponte sanctions. 1. Citations to record and standard of review. Okay. The question of whether a court may sua sponte sanction a litigant for violating Rule 26 in a manner that ignores the procedural requirements of that rule was raised at least 3 times below.
Oh, okay.
First, in Laura's motion for judgment on the pleadings on the exact issue. Second, in Laura's pretrial statement. And third, Laura's post-trial motion for new trial.
He's brought it up 3 times. Why is nobody listening to him? It's almost as if it doesn't matter.
Or we don't care. We do not care.
We don't know.
Both substantive motions were denied with no explanation for the trial court's position. Laura's motion for judgment on the pleadings was denied by minute entry order dated May 28, 2024, in which the court held the issue of sanctions was moot. Laura's post-trial motion for new trial and other relief was denied by a 1-line minute entry order dated September 6, 2024, which contained no discussion at all.
The horror.
It's almost like she's a judge and she just said no.
No. No.
I mean, no is a complete sentence. I don't know. My parents used to just say no, and there was no discussion. I feel like, she's the mommy of her courtroom if she wants to say no.
Right?
No.
But there was no discussion at all. I wrote all those pages, and all she wrote was 1 line back, which
No,
is
she didn't tell you what you wanted to hear.
When you write somebody a long thing and they just like respond back K, you're just like, okay.
That's what the judge should have responded to all of his motions. K. Thumbs up emoji. That would have been funny.
We're just dumb mortals. Damn Montana. Oh gosh. He's always entertaining. I'll give him that, even if it makes my
I
brain hurt.
well,
Because
if
my
he
brain
wasn't
does hurt.
entertaining, would we be having any fun?
That's true. It's fair point.
Both substantive motions were denied with no explanation for the trial court's position. Laura's motion for judgment on the pleadings was denied by bench. Okay, did I already read that? Yeah, I did.
Yeah, you're down here when sanctions.
When sanctions are challenged purely on factual grounds, an abuse of discretion standard apply. Oh, that's strong wording.
Oof.
Okay, I don't know what we review. Okay, I don't need to read that. However, when sanctions are challenged as to their legal basis, review is de novo. Whether the basis for awarding fees is proper is an issue of law that we review de novo. Okay. I think
Not so little Llama. I was gonna say not so little Llama is taking Latin this year, so I guess I'll be learning Latin this year.
Just ask ChatGPT. I don't need to learn it. I have a machine that'll tell me the answer.
Oh. I can't wait.
Discussion. He wants to have a discussion.
Oh,
Summary
great.
of Rule 26's requirements. Oh, for
Oh my God.
fuck's sake. All right, guys. Thanks for joining us. I can't take any more.
This is torture. The government should think about reading this in like Guantanamo or something. Like, oh my God. Do you think the appellate judge has read all of this? Like,
no, I don't. I think they paid an intern. Just TLDR.
right. Oh, Latin's
All right.
fun. We didn't have it at school.
Rule 26 is simple, clear.
Is it?
Just positive. Isn't
it
that
though?
like, I feel like that's a quote from Legally Blonde. The rule of law is clear and finite, or something like that. Or the rules of hair care are clear, something like that. Okay. Rule 26 is simple, clear, and dispositive of this appeal. Because the correct interpretation of this rule presents a threshold question of law, which this court considers de novo. Is this his new favorite word? Did that come up on his calendar words like that you just pull off and it's like, use this 20 times?
Yes, part of his like daily affirmation routine.
Yeah. It
Maybe
is
he's
worth
learning Latin
starting.
too. I don't know.
It could be. It could be. He's like, oh, I just learned this word. I'm going to use it every chance I get. Just like I walk around the house saying it's moot.
It's moot.
It is not worth starting with a basic discussion. Oh, it's not? Or it is worse. Never mind. Maybe I was just subconsciously putting the word not in because my body is rebelling against this whole conversation. Oh my God. It is worth starting with a basic discussion. It is not of how, oh my God, really? Of how Rule 26 should work. We're doing this, guys. We're doing this.
Oh my God.
Followed by an explanation of how the rule was clearly violated here.
But we thought, what have you been doing the last 23 pages, David? I thought you've already explained how it was violated, but okay. All right, fine. David. Okay.
I think this was a punishment for JFC. I think he's like, you know what? They're all going to read this on their streams. I'm going to make this as painful as possible.
I believe it to be true. Yes.
Every lawyer is familiar with how Arizona civil law and its lesser known but substantially identical sibling, family law, Rule 26 function. Both rules require a party or attorney to certify each pleading is believed to have at least some minimal factual and legal merit. Well, end of story.
We're done. We're done here. You win. You win all the things.
Well, no, you got nothing. And a reasonable inquiry has been performed before the pleading is filed. That part is obvious. Regarding factual allegations, Rule 11 and 26 have never demanded perfect accuracy. Wait a minute. So the truth doesn't have to be accurate?
Well, rules are usually, okay. All right. I wasn't expecting it to be perfect, but this is egregious. Okay.
He's lost me on this argument already. Rather, the rules only require a party to certify the factual contentions of evidentiary support, or specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. In this way, Rules 11 and 26 have always forbidden a party from making knowingly false allegations of fact, but this is a low threshold to clear. Rule 11 sets a low bar. It deters baseless filings.
Really? You think there's been any baseless filings in any of this? I think so. I think there has been by his client.
I am just.
By his client.
It deters baseless filings by requiring a reasonable inquiry that there is some plausible basis for the theories alleged. When there is a plausible basis, even a very weak one, supporting the litigant's position, imposition of civil Rule 11 sanctions is inappropriate.
I forgot. You're reading from
versus United States. Yeah. If a party has plausible basis to believe a factual allegation may be true, the rule does not allow sanctions simply because that belief is later proven incorrect. A reasonable but mistaken belief does not violate the rule.
So
that's what I'm saying. I'm lost on his argument. His argument has lost me here.
Continue on with this nonsense, David. Continue on.
I'm not David. I'm just reading it. I'm just reading it. I don't even know where I'm at.
I think here.
Okay, doesn't. In this way, Rule 11 and 26 bar knowingly false claims, but they also provide leeway for parties to bring cases based on what they think is true at the time, even if that belief turns out to be completely wrong.
That's his argument for Laura doing all of this. Well, she believes she was, so it doesn't matter, which is preposterous.
Okay. When a pleading is filed in violation of these requirements, Family Law Rule 26, like Civil Rule 11, sets forth a crystal clear 3-step process to follow. This process must be followed before sanctions may be requested.
It is textual man-splaining.
Oh my God.
He's going to break
us the steps.
It's okay. We're going to be fine, everybody. We're here together for support. No, I love y'all are excited about Latin. I wish I would have known earlier because my son's grandmother was a high school Latin teacher. Not all schools offer it, but his does this year. I was like, damn, guess we should have been teaching you it all along. But anyway, here we are. Okay,
party. Wait, you froze. Oh, there you are.
I'm here.
The party claiming the violation must make a good faith effort to talk directly with the alleged violator. In family court, this conversation must satisfy Family Law Rule 9C, which states the discussion must be in person or by telephone and not merely by a letter or email. Damn it, he wanted that lunch.
He did. He wanted that Top Golf nacho beer drinking lunch with Whitnick so bad. Like I tried. I even asked the judge to make him be my friend. Wouldn't.
I even tried to bribe him with nachos.
And golf. To get rejected on a date or from a date in a court filing is very embarrassing.
Step 2. I'm going to read the the 10 dual commandments. We're going to do step 2. I'm going to read this in a Hamilton rap.
Nice.
If the issue is not resolved at step 1, the party claiming the violation must serve the opposing party written notice of the alleged violation. See Arizona Rule Family Law, blah, blah, blah. Notably, Rule 11 previously required service of a full draft motion for sanctions, but that requirement has been changed to a written notice of the alleged violation, not a motion.
Okay. But didn't they talk about Whitnick and them? Didn't they write several things that they believe she lied on, like in January, I thought, or did those not come up till later? I don't remember. I mean, I'm just saying, I think Whitnick filed a whole ass motion. So, but okay.
I mean, it's probable that he did, and I can't imagine that he wouldn't. But it's like Gingras has a barrier. Like only certain things actually get through, and like the other stuff just doesn't exist because like it's just. Just
and we
bounces off.
read
I don't know.
we read their emails back and forth. We know that he was very difficult to talk to on the phone. He wanted their attention all the time. He was very extra. Let's just put it that way.
Yeah. Step 3. Well, you probably wanted to run up their bill too.
Oh yeah, 100%.
Yeah. After the alleged violator is served with the written notice required in step 2, they have 10 business days within which to withdraw or appropriately correct the alleged violation. If the violation is corrected or the pleading withdrawn within this safe harbor period, sanctions cannot be imposed or even requested. Thank you for clarifying that. I needed a 3-step process.
3 steps.
Because
guys.
the other 20 paragraphs you provided previously did not clear it up before.
It's for us simpletons.
And all the other motions that we read about Rule 26. Like,
right.
Thank you.
I gotta go to the bathroom. I'll be back.
Clayton did not comply with Rule 26 procedural and safe harbor requirements. As explained supra, Laura raised the issue of Clayton's non-compliance with Rule 26 multiple times. First, in a motion for judgment on the pleadings, and lastly, in her post-trial motion. Unfortunately, the trial court denied Laura's post-trial motion before Clayton responded. However, Clayton did provide a helpful response to Laura's motion for judgment on the pleadings. Clayton's argument in that brief shows he knowingly failed to comply with the Rule 26's procedural or safe harbor requirements. To begin, Clayton failed to comply with Arizona Rule Family Law, blah, 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 26 and Rule 9C, which required him to have an in-person or at least telephonic conversation with Laura. Oh, can you imagine how that would go? Prior to seeking sanctions. I guess that just means the attorney. It's not necessarily them two together because I can see that going over like a turd in a punch bowl. There's your other Southern saying, Llama. All right, let's see. It is undisputed. Clayton ignored the requirement because his later filed and then withdrawn Rule 26 motion admitted as much, as did his response to Laura's motion for judgment on the pleadings. Specifically, in the good faith consultation certificate attached to the original motion for sanctions, Mr. Woodnick never claims he made any effort to speak directly with Laura about the specific issue of Rule 26 sanctions before the motion was filed. Instead, Mr. Woodnick's certificate claimed Clayton complied with the conferral requirement because more than 4 months earlier, in August 2023, he sent 2 text messages to Laura that indicated he could not be the father of her alleged twin fetuses. Those 2 text messages said nothing about Rule 26 sanctions and do not satisfy the rule. Mr. Woodnick's good faith certificate also claims he had 1 phone conversation with Laura's prior counsel on December 27, 2023, the substance of which is not mentioned in the certificate. But even assuming that call included a discussion about sanctions, this only proves Clayton did not meet the other strict requirements of Rule 26. This is because Mr. Woodnick claimed the phone call took place on December 27, 2023, and Clayton's Rule 26 motion was filed on January 3rd, 2024, just 5 business days after the call. Even if the phone conversation met the conferral requirements of Rule 26 and was followed by a written notice, Clayton did not provide the 10-day business day safe harbor required by Rule 26. I am so tired of hearing that word.
Okay.
I'm
What page are
so
we
over it.
On. Sorry.
Way past that.
Okay. Page are you on?
I am on page 21 in the very last paragraph.
Oh, okay. Perfect.
The violation is further established by the fact Clayton's Rule 26 motion did not include an attached copy of the written notice required by Rule 26. See Rule 26. Providing a motion for sanctions must attach a copy of the written notice provided to the opposing party under subpart C2B. That notice was not attached to Clayton's motion for one obvious reason. The required written notice was never sent.
Oh my God. We need a Mark Safe from Rule 26 shirt. Because I feel like this is torturous.
I'm so tired of hearing that word.
He helped write it, like the actual code rule thing. Oh, I did not know that. That's interesting. I don't know, because YouTube is being wild these last few weeks. I don't know what its deal is, but I'm over it. Hi, Steve-O. Yeah, he's a character, this Gingras guy, isn't he? He's quite a character indeed. All right, where were we? Beth. You're muted, babes. Oh, no.
That's because I had a coughing fit and was trying to spare you from that horrible sound. All right, so in his brief opposing Laura's motion for judgment on the pleadings, Clayton basically admitted these violations, but claimed they were harmless. In short, Clayton argued his violations of the rule were immaterial because Laura should have guessed from the other pleadings. Oh, God. Such as Clayton's motion for leave to amend, filed December 12th, 2023, that Clayton intended to seek sanctions at some point in the future. I mean, she should have known that. I mean, why? I feel like that should be a default, like, you should just already default to that thought, like, you know?
Yeah, I mean, isn't like lawyer fees and stuff usually part of all of the things?
I mean, that's why I'm saying that, like, in my head, it would be like, I know that there's a potential that if I lose this, I'm going to get stuck with these fees. I feel like that should just be the default thought for most people, but
well, for everybody, but not Laura, because she doesn't have to pay for anything ever, and she's obviously going to win, so the rules don't apply to her. She's a delicate little dewdrop.
Oh, okay. Let's see. Now I'm going to. Okay. However, as explained in FRA, the law on this issue is 100% clear. Passing threats, settlement demands, and or other oblique references to an intent to seek sanctions in the future do not satisfy the strict compliance standards of Rule 26.
Never mind. Don't forget that Laura emailed him and Woodnick and was like, you're going to pay me $1.4 million and I'll drop the case. But let's not
Yeah.
bring that up. How dare he ask for, lawyer's fees and whatnot.
Well, it's always rules for thee, but not for me.
Rule 26 for thee and not for me. Specifically.
It's true.
No, they
That's
didn't.
true. Okay, so C. Radcliffe versus Rainbow Construction. Explaining informal warnings, including a threat to seek sanctions made in other pleadings, do not satisfy the strict requirement that a written notice be served on the opposing party prior to filing. Emphasis in original, blah, blah, blah.
Blah, 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 blah.
Blah, blah, blah. C. Clayton's failure to comply with Rule 26 precludes any award of sanctions. Factually, Clayton did not comply with the strict procedural requirements of Rule 26. Even assuming the vague reference to a single phone call with Laura's former counsel on December 27th, 2023, included a discussion about Rule 26 and thus satisfied the conferral requirement of Rule 26, which is far from clear. It is undisputed after that call, Clayton did not serve Laura with a written notice as required by Rule 26. Nor did he wait 10 business days to give Laura an opportunity to withdraw her petition. Instead, Clayton's Rule 26 motion was filed on January 3rd, after Laura had already moved to dismiss the action with prejudice on December 28th.
But isn't that also like the same day she fired Lexi Linville? Like,
Carl, I can't remember any of the dates in this freaking case because the dates are just, they just move. They're moving targets. Everything changed. There's too many.
yeah, because she only had Lexi for like a week, and Lexi tried to get her to, sign something that she lied about being pregnant. And she was like, no, bye, and I'm going to file a bar complaint on you. And then she got Corey.
Okay.
Anyway.
The question thus becomes, could the trial court still properly award Rule 26 sanctions when the procedural requirements of the rule were not met? But Laura nevertheless moved to dismiss with The question, it is a question? Okay.
It's
the
a question.
thus becomes, could the trial court still properly award Rule 26 sanctions when the procedural requirements of the rule were not, it's a really fucking long question, were not met, but Laura nevertheless moved to dismiss with prejudice. This could have been asked with far fewer words, sir.
But then how will you know how smart he is? Bobby.
Oh my God. Surprisingly, published Arizona cases interpreting the safe harbor provision of family law Rule 26 and even Civil Rule 11 are limited in scope and largely silent as to this discrete question. As such, this appears to raise an important matter of the first impression for this court. Okay.
Right. After hours, I didn't think it was the awarding of fees and attorneys. Like, that's just a standard, right? Like, it didn't have anything to do with Rule 26. That was a way. Like, I don't think there was anything wrong with awarding the attorney fees because that's what happens. But all right. He's been stuck on this since his very first filing for extended time or extending pages and time.
Thankfully, this court will not write on a blank slate.
Oh, thankfully.
What does that mean?
That means that there's a fuck ton of precedence for it, I guess. I don't know.
Okay. Oh, yeah. He explains it in the next sentence. There is extensive federal authority on this issue, which this court may properly consider. And a bunch of case law is going to get cited. See, James Cook and Hobson's, blah, 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 blah. Federal courts faced with the same problem have repeatedly agreed When a party is accused of a Rule 11 violation, but the technical requirements of the rule are not strictly followed to the letter, or the accused party moves to dismiss, sanctions are unavailable as a matter of law under Rule 11 or any other authority.
Okay.
That straightforward result was succinctly explained. Succinctly? You could
Well,
take
it's
a lesson in succinct.
if you're David, then it is. It makes sense to him in his non-backspace.
No.
What?
This was written by someone else, so it was probably
Oh.
succinct. It was not written by him. That straightforward result was succinctly explained by a recent Maricopa County Superior Court decision, which perfectly summarized and then fully adopted the standards of Rule 11 by citing exclusively to federal case law. Citations remain as an original. Subsection 2 of Arizona Civil, the so-called safe harbor provision is intended to give the offending party the opportunity to withdraw the offending plea and thereby escape sanctions. A party is not entitled to seek or obtain Rule 11 sanctions if it fails to comply with the safe harbor requirements. Failure to comply with the safe harbor provision precludes an award of Rule 11 sanctions.
We don't have to read the rest of that. It's fine.
What's it? It's all a bunch of case law. Let's
It is.
see.
Well, it's like we can skip all this. I don't really care. It's all stupid. Here we go. We can pick up here.
This result that sanctions cannot be awarded when the procedural requirements of the rule are not followed or a party moves to voluntarily dismiss is not only required by the plain language of the rule, but also by the underlying purpose of the rule to streamline resolution of cases by encouraging parties to withdraw unattainable claims without fear of life-altering consequences. The Ninth Circuit has recognized that core purpose.
Okay.
Bunch of case law.
All right.
It's just a restatement of what he wrote up there.
Yes.
While our state court decisions have been less clear about the safe harbor's purpose, Arizona courts have nevertheless agree. Rule 11 share the common purpose of promoting judicial economy by deterring meritless and wasteful litigation.
But it's not wasteful because Laura believed, guys. She believed that she was.
I mean, it's kind of low-key saying that it was. Again, while there is a dearth of published state court decisions on this issue, federal courts have answered this question repeatedly. Laura explained this at length in her motion for judgment on the pleadings. In that motion, Laura cited several extremely helpful cases, including Westerkamp versus Mueller and Radcliffe versus Rainbow.
Because David is so helpful.
The defendant gave written notice threatening to seek Rule 11 sanctions based on a frivolous pleading filed by the plaintiff 8 days later within the safe harbor period of Rule 11. As Laura did here, even though no valid written notice was ever sent, the plaintiff moved to voluntarily dismiss the case in Westerkamp, despite the plaintiff's clear attempt to invoke the safe harbor rule of Rule 11. By moving to dismiss before sanctions were sought, the defendant still moved for sanctions. The district court denied the motion. The court held Rule 11 sanctions were unavailable as a matter of law because plaintiff had every right to invoke the safe harbor without punishment. I am so over this argument, dude.
Right?
Move on. Is this
over.
it?
We'll see.
Defendant's basis for even threatening to seek a Rule 11 sanction based on the allegedly frivolous pleading, let alone formally moving for such sanctions, evaporated on March 2nd, 2023, when plaintiff's counsel offered to stipulate to a dismissal of the entire case with prejudice. Because the alleged wrongdoers in Westerkamp offered to withdraw his complaint and dismiss the action within the safe harbor, and before the defendant moved for Rule 11 sanctions, the court held it was powerless to even consider sanctions. Once plaintiff moved for voluntary dismissal, defendant was precluded from filing the Rule 11 motion.
Okay.
Is that what that case law actually says, though?
I don't know. Do I care?
'Cause
I do not. And
I
I
mean,
love
sometimes they like read case law and then it kind of like it doesn't really say what they think
Mhm.
it said. I don't think it means what you think it means, but
Yes. Yes.
the posture of Vesterkamp is not similar to this case. It is identical. Here, like in Vesterkamp, Laura commenced the proceeding, but then once Clayton's counsel verbally threatened sanctions, Laura immediately moved to dismiss with prejudice the very next day. But I thought you said he didn't threaten sanctions. Like I thought you said he wasn't she wasn't properly noticed. So I'm kind of
And
did I
the
read
phone
that
call
wrong?
was vague.
Like
Remember?
that's what I'm saying. Did I read that wrong? Am I misunderstanding? Because I feel like there was like 20 pages prior to this where you said that it never happened, but now that here, you're saying it happened. Oh, because it was verbal. I'm sorry, that doesn't
Mhm.
count.
Even though they're supposed to have phone calls or meets, according to because email does not.
Aren't
not
meetings verbal?
Don't focus on the stuff, Buffy. Jeez.
Are we just like holding up, like writing it on paper while we're not having verbal? Okay. I have questions. Once Clayton's counsel verbally threatened sanctions, Laura immediately moved to dismiss with prejudice the very next day on December 28, 2023, before Clayton's Rule 26 motion was filed. As the court held in Vesterkamp, the fact Laura moved to withdraw her petition before any motion for sanctions was filed caused the basis for Clayton's motion to evaporate. In short, no. Once Laura invoked the safe harbor, her reward was protection against sanctions. The timely withdrawal of a contention will protect a party against a motion for sanctions. Here, the trial court plainly erred when it ignored the law and refused to accept Laura's safe harbor invoking motion to dismiss. The court further erred as a matter of law by sanctioning Laura after she invoked the safe harbor. Both errors require reversal of the sanctions award and remand with instructions to grant Laura's request to dismiss with prejudice. This conclusion is further supported by another helpful and even more closely analogous case cited by Laura in her oh my god. Okay. In her motion for we're going to go through another one. On the pleadings, Radcliffe versus Rainbow Construction. In that case, like here, the defendant filed a motion for Rule 26 sanctions without first providing a written pre-motion notice to the alleged offender. Procedurally, like Vesterkamp, Radcliffe is identical to this case.
So many identical cases. So many.
It's exactly the same. Even though Rainbow failed to follow the requirements of Rule 11, like Clayton, the trial court held sanctions could still be awarded on the court's own initiative. The same legal conclusion applied here. In fact, like Judge Mata did here, the trial court in Radcliffe held a literal application of the safe harbor provisions was unnecessary in this case. The trial court then awarded $75,000 in sanctions to Rainbow.
Well, how is this different then? I don't understand.
On appeal, the Ninth Circuit reversed. The court explained when a party seeks Rule 11 sanctions, they must comply with the text of the rule. Compliance is mandatory, not optional. When strict compliance does not occur, a trial court cannot gratuitously fix the mistake by converting a defective Rule 11 motion to a sua sponte motion, even though Rule 11 otherwise permits sua sponte actions. The Ninth Circuit rejected this attempt to end run around the rule's safe harbor. Thus, to ensure this safe harbor was not stripped of all value, the court held a non-compliant Rule 11 motion by a party cannot be converted into a sua sponte motion by the court because doing so would eviscerate the safe harbor function of the rule. We reject Rainbow's argument that the district court's order for sanctions can be interpreted as a Rule 11 motion of the court's own initiative. This provision does not require 20-day advance notice. We reject Rainbow's contention because it was Rainbow, not the court, that initiated the award of sanctions. The district court's discussion of the safe harbor provision in its order concerning sanctions serves to emphasize this point. It would render Rule 11 safe harbor provision meaningless to permit a party's non-compliant motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. Because Rainbow did not follow the mandatory service procedure of Rule 11, we reversed the award of sanctions.
I'm going to be honest. I don't understand why everything is so, like, why do I have to file certificates for every single thing that it seems obnoxious and a lot like unnecessary paperwork, unnecessary hours of work. I don't understand the purpose and the point of doing these extra steps afterwards. It doesn't make sense to me. I'm sure there are reasons for it, but I'm just like, this just seems like just such a waste of fucking time. But I know it's a big deal because in all of the Karen Reed civil cases, I typed in all of this crap that they have to do as well when filing every single thing they do. It's so annoying. They have to have a conference. They do like Rule 9A and 9C and blah, 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 blah. It seems stupid. I don't get the point.
The point is to bleed you dry.
Yeah. Like I don't get why you have to have like a one piece of paper being like, yup, we talked. Like, okay. I'm sure there's, like I said, a valid, rational reason for it. It's stupid.
Well, it's like you have to document everything. We had a conversation. You know, if you don't write it down, it never happened. You got to file it with the court to prove that it happened. Otherwise, it doesn't exist. I mean, just because I understand why it happens doesn't mean I agree with it. I can understand and also not agree.
Yeah, that's true. Well, I think it's stupid.
Oh, that's what I'm saying. I can understand why they want it, but I don't agree with having to, like, I think it's a waste of time and money. But I understand why they need it. I just think it's dumb. I hate this guy. The Ninth Circuit in Radcliffe got it exactly right. Rule 11 and family law Rule 26 are not single-sided coins used only to punish. On the contrary, these rules serve powerful dual functions, acting as both a sword to punish bad conduct, but also a shield to encourage and reward good behavior by allowing pleadings to be withdrawn without fear of crippling sanctions. That is the whole point of a safe harbor, to provide safety.
Oh, thank goodness he bolded and underlined that.
I'm so glad he explained it, because I wouldn't have gotten that at all.
Not at all. It's very hard.
It's very hard for me to figure out. It took you 37 pages. Okay. To be sure, Rules 11 and 26 do allow courts to punish violators sua sponte when the facts warrant it. You know what? That's his whole problem here. It does allow it, and I think it does warrant it. I don't. This was a ridiculous lawsuit to bring.
Agree.
Otherwise, you wouldn't be in a criminal court having committed a criminal crime.
I think he does too, Peachy Teach. She says Dingus seems to be the kind of guy who congratulates himself on the smell of his own farts. Yes.
High five.
Agreed.
Courts have noted sua sponte sanctions are extremely rare and will ordinarily be issued only in situations that are akin to a contempt of court.
Never mind, she recommended his client to the DA, but
us.
All right, we don't need to read this part. No.
Thank God. I thank you for having a little mercy on me.
We can start here. That's fine.
I felt like I was being sanctioned for a minute.
Llama, why are you torturing all of us?
Ugh.
Dear Montana. Llama and Buffy, you amuse me trying to figure things out with your tiny female brains. So adorable. Oh, we're so stupid.
I don't claim to know anything. I'm figuring it out as I go along.
Right? Oh, goodness. I can't wait till this part's over. It's fine. We're almost there.
My tiny little female brain has got like 20 tabs open. So it really focuses on one thing at one time.
I'm about to
And
file
most of the
sanctions
time,
against him.
the wrong tab is got all the power going to that, not the one I'm actually working on.
Yes.
So here, the trial court never issued any show cause order to Laura. That fact alone precludes sua sponte sanctions. In addition, Laura moved to dismiss her petition with prejudice immediately, literally the very next day. And after Clayton's counsel spoke with her counsel, this voluntary I just kind of made that a run-on sentence because mostly that's how he writes. After Clayton's counsel spoke with her counsel, this voluntary dismissal before a show cause order was issued also separately precluded an award of sua sponte sanctions. Either or both of those points are sufficient, standing alone, to require a reversal on the judgment of this case. Okay, if we move to your next point, you've hammered that one home. The horse is dead.
Well, don't worry. There's still 43 pages.
Yeah, but
33
I'd like for
pages.
him to argue a different point. Okay, because this one is like so dead. Like it's like I'm over it.
You've ran over the horse, David. Way to go.
Because the trial court did not follow the mandatory process for ordering sua sponte sanctions, that means the only remaining option was for Clayton to move for sanctions. But as noted above, Clayton's Rule 26 motion was procedurally defective and later withdrawn. As such, to the extent Laura was sanctioned as a result of Clayton's motion, reversal is required. Rule 11 sanctions are not appropriate, given the safe harbor provision, unless an offending party has an opportunity to withdraw the complaint without suffering sanction. More case law. It's like this, it's like the exact same stuff over and over again.
That's fine. You can skip it. Sorry, I'm heating my coffee.
I would need another page.
Okay.
I'll go down. Hold on, I got it. By design, rules 11 and 26 permit even the most malicious wrongdoer to change his mind and withdraw a disputed pleading without punishment. As the saying goes, that's a feature, not a bug.
Okay.
You know what? I'm using that. Whenever someone says something ridiculous about me, I'm going to be like, you know what? That's a feature, not a bug.
I don't know, but I feel like this filing is overly burdensome to me.
Right? It's an undue burden.
Yes.
Unduly burdensome. It's overly broad and unduly burdensome.
Yes. Look at us learning civil things. I spilled my coffee on my desk. Mess.
Oh, you always do that.
I know. One of these days I'll learn. Not today, though. Not today. I'm busy learning about Rule 26 because what would my life be without knowing it? I don't know.
I'm so grateful that we had this review. I'm so ready for my law test. Take the bar test. Yeah, I'm so ready. I know I'll pass that question. The safe harbor is offered to all takers, not just the innocent ones. A party can take the safe harbor because of a good faith mistake. Or a party may withdraw a pleading because they feel the risk of proceeding is just not worth it. In short, the reasons are not relevant. Rule 26 is blind to the wrongdoer's intent or motive. Whatever the reason may be, Rules 11 and 26 allow parties threatened with sanctions to raise the white flag, invoke the safe harbor, and safely withdraw their offending pleading without fear.
Oh, that's good because Laura is afraid of everything all of the time. So she's probably locked in a room since then. That motion, that scared me. The motion for sanctions, it was so scary. David, call 911. Their motion.
Under these facts, and for the same reasons explained by the Ninth Circuit in Radcliffe, the District Court in Westerkamp, and the Superior Court in Gallagher versus Serrano Law Offices, the trial court erred as a matter of law by awarding sanctions to Clayton. Laura's timely motion to dismiss her petition with prejudice terminated Clayton's right to sanctions as a matter of law. Accordingly, this court must reverse the judgment and remand this case with instructions to dismiss the action with prejudice and should have occurred in response to Laura's motion filed on December 28, 2023. See Holgate versus Baldwin. We must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Okay, got it. Are we still talking about Rule 26? Holy fuck, I thought it was the end.
Oh my God.
Rule 26's safe harbor protects Laura from sanctions under other authority. Good God, sir.
David.
This is unnecessary. And I'm filing for an intentional infliction of emotional distress.
Exactly.
Assuming the court agrees the award of sanctions under Rule 26 was improper, a different but related question must be addressed. Could Laura still be sanctioned under other authority, such as the court's inherent authority? The answer to that question is no. Rule 26's safe harbor shields Laura from any punishment arising from her alleged violation of Rule 26.
Right, but there can be other things that.
But see, that's the last part of that. From her alleged violation of Rule 26. That's the only one she can't be held responsible, like liable for. But there can be other sanctions. Right?
Yeah, that's my understanding also based on what After Hours Respawn said about it. So I think so.
That conclusion is required by several different points of law. First, as noted above, the central purpose of the safe harbor is to ensure a party can withdraw even frivolous pleadings without fear of life-altering punishment. This quid pro quo benefits the courts and litigants by streamlining litigation and by making it easier for parties to drop claims early without risk of endless satellite litigation, such as occurred here.
Oh my God, he was obsessed. It was weird.
Well, I don't think that's fair anyway. Like, even if that is actually true, it's not really fair. You can sit there and file all of these frivolous lawsuits against me, which I now have to get a lawyer to defend myself against. And then when my lawyer threatens you with this frivolous lawsuit, you can just be like, okay, I won't do it.
That's how they want it to work.
You get a and then you're not responsible for anything that you just like did. Like, I feel like if that's the intention of like stopping frivolous lawsuits, there should be sanctions about that.
I would think so. But I think that's where the other possibilities of sanctions come in. Well, of money and stuff besides Rule 26.
Yeah, I don't know. I guess I just feel like if people would be like held responsible monetarily for bringing these stupid shit into the court, our courtrooms wouldn't be bogged down so much, you know?
Mm-hmm. Agreed.
Maybe I'm just looking at it wrong. I don't know.
I'm right there with you.
Okay, so Indeed, the Ninth Circuit has recognized the value of Rule 11 comes from the safe harbor, allowing people to withdraw claims safely. Under the former rule, parties were sometimes reluctant to abandon a questionable contention lest that be viewed as evidence of a violation of Rule 11. Under the revision, the timely withdrawal of a contention will protect a party against a motion for sanctions. This is also why, as noted above, the Ninth Circuit held, what was that?
Dan Montana says, do you think the judges find his motions offensive? He is so unnecessarily repetitive. Like the judge can't remember what Dingus wrote 2 pages ago in the same motion. I'm
Judge
offended.
Gilday would have thrown a fit.
That's true. That's true. That's the judge for the Karen Reed civil trial. Well, for 2 of them.
I will tell you that judge would have pulled him in and read him the right. Stop giving me this stupid crap.
Mhm. Absolutely.
Like, can you make this shorter? Because remember, he told them that in the hearing the other day. Like, oh, you don't want any of that? No, I don't want it to be so long. So you don't want it to be long? No, I want it to be short
and relevant, please and thank you.
Okay.
Where were we?
I don't know. This is also why, as noted above, the Ninth Circuit held in Radcliffe that a defective Rule 11 motion cannot be saved by converting it into a sua sponte motion based on a trial court's own authority. Even though Rule 11 otherwise permits sua sponte actions using an OSC process. See Radcliffe, blah, blah, blah. In plain English, a safe harbor that provides no safety from punishment is no safe harbor at all.
It's just a regular old harbor.
I bet he felt like he felt like he ate with that.
Probably. He's like, that's so good,
yeah,
David. Good job, buddy. Yes.
For that reason, Rule 26's safe harbor must be construed as not only shielding litigants from punishment under Rule 26, but also from punishment under any other authority, to the extent the punishment is based on the same conduct that allegedly violated Rule 26. That conclusion is required by both the language and intent of Rule 26, but also by the general legal principle, long applied by Arizona courts, that where 2 rules deal with the same subject, the more specific rule controls.
We're going to skip all that part.
Thank God.
We'll go to be sure.
To be sure. As Clayton correctly argued in his brief opposing Laura's motion for judgment on the pleadings, many other rules, statutes, generally authorized sanctions for various different types of litigation misconduct. Blah, 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 blah. See, blah, blah, blah.
Blah, blah, blah.
I don't know. I just hate it. Like citing case law. I'd rather read his arguments than just. I know case law is a thing. I know it has to be done, but I just hate reading it. At least on that one point, Clayton is right. What? Write that down, y'all.
Oh.
Numerous other rules and laws of general application do permit sanctions, including, for instance, ARS 12-349. But when a party claims a specific act violated Rule 26, as Clayton did here in his counsel's very first filing, asking this court sanction petitioner under Rule 26, the question is whether a specific violation of Rule 26 can also separately be punished under some other rule or law of more general application.
But here's finish the sentence. I'm sorry. Go ahead.
I would say such as ARS or the other laws mentioned in Clayton's brief, like this other law.
So his argument here is very confusing to me. Most of this is very confusing to me. But so he said, oh, they can't use the Rule 26 because they didn't send the certificate. And then they withdrew it. So that can't happen anyway. And now this part, he's saying, well, where was I going with this? That They can't punish Laura based on anything that was said in that Rule 26 and the reasons why. So therefore, she can't be punished at all. But if Clayton withdrew that, which he did, that means it doesn't exist because it was withdrawn. So therefore, wouldn't they still be able to do sanctions on the things that they accused her of in the Rule 26? I don't understand what he's trying to, because that would make sense to me, right? It's not like they withdrew
That's what
it.
I've been arguing this whole time. Like there are other things.
But now he's saying, well, if it was mentioned in there, we can't sanction her against it. Well, is it completely withdrawn? Therefore, there could be no sanctions, or does it still count, but we can't sanction her based on anything they said? I don't understand.
I never.
Somebody much smarter than me might be able to explain it. I'm like, I don't. Right? It exists and works sometimes in your argument, but then other times you're like, no. Okay.
Oh my gosh. Sorry. I got like a crap ton of messages. Anyway, and I just make sure it wasn't my kid. So the answer is clearly no.
Okay. Is it clear? I don't think it's clear, David. In 44 pages, you have not been very clear. For sure.
It's clearly no, Llama.
Clearly.
Because he says so.
I'm an idiot with my tiny female brain. You're right.
Clearly.
So stupid of me.
Clearly, a tiny female, but he's going to explain it to you since your brain can't figure it out.
Great, because I need another 20 pages of this.
Oh, ask and you shall receive. He is here to provide that for you.
Excellent.
This is so because a violation of Rule 26 must be governed by the terms of Rule 26, including the rules safe harbor. I think he's just rephrasing things in different ways and just repeating it over and over because read that sentence back.
That is
this is so because a violation of Rule 26 must be governed by the terms of Rule 26, including the rule safe harbor. That was a nonsensical statement. What the hell? Okay. Rule 26 is a highly specific law which addresses exactly the type of conduct Clayton accused Laura of committing, filing a baseless petition. Oh, okay. In addition to prescribing exactly that conduct, Rule 26 also sets forth a very specific process for how a violation should be addressed and how the violator may or may not be punished for the violation. Rule 26 could not be more directly applicable to the conduct in question. The rule, therefore, controls exactly how and when sanctions may be imposed and how and when they may not be. As such, even if other general rules could arguably reach the same conduct, Rule 26 must control and must provide the exclusive remedy for a violation of Rule 26. When a statute creates a right, and also creates a remedy for the right created, the remedy thereby given is exclusive. Okay. The rules of civil procedure have the force and effect of a statute. The limitation is explicitly acknowledged by general laws such as ARS 12-349, which permits sanctions for unjustified actions, but only in a manner that is consistent with other more specific laws, like Rule 26. Let's see.
Good news
that
is
limitation
that the waters went down in my basement.
Yay.
Probably have about like ½ inch to an inch of water left, which is pretty
you almost had an indoor pool.
Yeah, I mean, based on this line on my cinder blocks, it looks like it was about 6 inches, 5 to 6 inches probably in the basement. So,
wow.
Yeah. Sorry, I have to take pictures and send them and stuff. Carry on.
Okay. That limitation is in fact expressly written into ARS 12-349, which allows courts to impose sanctions in general, but only except as otherwise provided by and not inconsistent with another statute. Here, putting aside the fact that Clayton never actually moved for sanctions under any other authority after withdrawing his Rule 26 motion, the trial court nevertheless concluded, like the lower court in Radcliffe, that sanctions could be imposed under other legal authority without need for a motion and in a manner that was entirely inconsistent with Rule 26, that holding was plainly wrong as a matter of law. The holding was wrong because if a party withdraws a pleading in response to a threat to seek Rule 26 sanctions, the safe harbor provision of Rule 26 must provide meaningful protection by allowing the error to be corrected without sanctions under other rules. This safe harbor is needed to ensure the rule functions as intended, incentivizing parties to promptly drop claims when challenged without fear of life-altering punishment as a result. If a party invokes the safe harbor of Rule 26, as Laura did here, but is then punished under other authority for exactly the same conduct that violated Rule 26, the safe harbor will literally be stripped of all meaning. This court must firmly and clearly reject that outcome. Is that how, like, that's kind of weird. I mean, okay.
This guy, I am so over him saying the same thing over and over again. All right, keep going. I'll be in a minute. Just scroll down.
I got it on my end. I don't know what you're doing on your end because I have to pull it up on a different tab. The trial court committed structural error requiring automatic reversal by performing an independent investigation into the facts. Oh, okay. Now we're back to other arguments. That's great. I'm so glad we're here. Citations to record and standard. Citations to record, not record. Okay. Citations to record and standard of review. Laura raised the issue of structural error in her post-trial motion for a new trial. The factual basis for Laura's argument, misconduct by the trial judge, was also raised in her notice of change of judge for cause and supporting affidavit of counsel. The notice of change of judge was denied by the presiding judge on August 13th, 2024, and the motion for a new trial was denied by a one-line minute entry order dated September 6, 2024. As for these points, the standard of review is de novo. We review both constitutional and structural error claims de novo. We will defer to the court's factual findings, but we review de novo its ultimate legal determination. State versus Dayton. 2. Discussion. Assuming this court agrees with Laura's interpretation of Rule 26, the inquiry ends. The safe harbor is dispositive of this appeal, and the court need not consider any of the other issues other than Laura's request for fees.
Is this a threat? Because I feel like yes, probably. Because she was unduly forced to pay, so she deserves the money now. But also, like, I feel like this is a threat. Like, if you accept this, you won't hear from us again. I mean, I know that's how like it works. It's not a threat, but I'm interpreting.
It's if you agree with everything I said above, you can stop reading here. I'm done. But if you're not convinced, keep going.
Like, have I exhausted you yet with my argument?
It's a flow map
that you're just going to say yes to because you're tired now and your brain hurts.
I'm telling you,
that's exactly how I feel.
It's just an intern reading this and giving the Cliff's notes to the judge. Okay. However, if this court chooses to part company with the extensive authority supporting Laura's interpretation of Rule 26, the lower court's judgment still cannot stand. This is so because, as Laura explained in Laura's notice of change of judge the supporting affidavit, and Laura's motion for new trial and other relief, clear and irrefutable evidence showed the trial judge committed structural error, resulting in a violation of Laura's constitutional right to due process. This violation occurred when the trial judge performed an independent and undisclosed investigation into the facts of this case and made post-trial findings based not on the evidence admitted at trial, but rather on social media posts published on the internet after the trial concluded.
Okay.
Although the presiding judge rejected this argument insofar as it was raised in Laura's notice of change of judge, and although the trial court denied Laura's motion for a new trial, structural error is subject to de novo review.
Now we are going to hate that phrase too.
I
Thanks,
already did.
David. Thanks.
Sounds like a car
Everything.
name. The de novo. Drive
Ooh.
the de novo. I don't even know
That
what
is
that means.
That is a good, a fancy sounding name. Let's
Well, that's
see.
what I'm saying. Like, it sounds like it's like, buy yourself a de novo. But what does it mean?
It means a new and from the beginning or a fresh. So that works for,
That would
for
make
cars,
a great car name.
right? Are we going to go
The
into
de
the
novo.
car making business? Why not?
I think it should be a new nail polish color.
Oh yeah, that's right. I forgot we are putting out a nail polish line, guys. I think on the True Crime and Wine Time post or something, we're taking like names and ideas for colors of nail polish. Yeah, we're gonna have our own nail polish line.
I think we should have a color called Safe Harbor.
Yes, write that down.
Oh, Lord. Okay.
Finger
To help
banging.
No, I don't think you should have a nail polish color called finger banging. Although that is kind of
Swear your
apropos.
fingers, you perverts. Anyway.
I want the color. What are you wearing? Oh, it's called finger banging.
It's called finger banging. The Rule
Like,
26 colors
seriously,
is
is that the color?
jet black. Because it's a hole that we're in. It's taking all the light out of us. That's Rule 26.
I'm telling you, that would, I mean, whew. Okay. Well, at least we're on to a different argument. Yay.
Are we?
It sounds like we're on to,
Structural
hey,
error?
the judge was on social media.
Oh yeah, that's right.
To
We're getting through it, friends. We're gonna be okay.
help summarize the structural error problem, clearly, the single most important and most aggressively disputed fact below was the question of whether Laura was ever actually pregnant. It's literally the foundation of the entire fucking case, but okay. Laura claimed that prior to filing the establishment petition, she tested positive for pregnancy 5 times, including the surprise unannounced test given to her by Clayton, which he later confirmed in writing was positive for pregnancy. Indeed, Clayton not only admitted to seeing the positive test, he took a photo of the positive test and emailed it to Laura.
Right.
Despite this compelling evidence of pregnancy, it's not really evidence of pregnancy. It's just a positive test. There are other supporting evidence of pregnancy. Oh, y'all are so resting on this positive pregnancy test.
Right? 5 times, Buffy.
Oh my God. Okay, so Clayton theorized Laura somehow faked the pregnancy as a way of trapping him into a romantic relationship. To support this theory, Clayton retained a medical expert, Dr. Samantha Deans, an OBGYN who previously worked for Planned Parenthood on the East Coast. In her expert report, Dr. Deans never claimed Laura was not pregnant. Well, she didn't say she wasn't. Instead, Dr. Deans expressed an opinion that a woman cannot be regarded as clinically pregnant unless the pregnancy is confirmed by an
Oops, sorry. I was looking at nail polish comments. Gosh. The cool blue. Like it.
focus.
Okay.
By an ultrasound or other clinical signs of pregnancy. Based on this strange technical definition of clinical pregnancy, Dr. Deans opined because Laura did not provide a verified ultrasound, that meant it was impossible to know whether she was clinically pregnant, implying Laura was never actually pregnant at all, whether in the clinical sense or otherwise. We cannot confirm by any objective data that Ms. Owens had an ongoing viable clinical pregnancy at any time in the last year. Clinical pregnancy is defined as a pregnancy diagnosed by ultrasonographic visualization. No, that word. One or more gestational sacs or definitive clinical signs of pregnancy. In addition to intrauterine pregnancy, it includes clinically documented ectopic pregnancy. We have received no verifiable documentation of a clinical pregnancy as defined. Okay.
Which is why nobody believes her, David. She's the one who claimed being a special snowflake of being high risk pregnant with twins. And yet,
there's no
nothing.
Documentation at all.
Mhm.
At all.
At all.
Gotta say, at all. Gotta say it the way you do. Thus, according to Clayton, the existence or absence of a verified ultrasound was the single most important evidentiary issue in the case. Just one small problem. Laura could not provide a verified ultrasound.
Why is that?
The reason? Because there was none. Well, he's going to tell you. The reason why is the crux of the problem. And it explains why, beyond question, the trial judge committed structural error.
What? Okay. You mean the one that your client now has charges for falsifying it? Is that why? You're right. It's the judge's fault, but continue on.
In short, before Laura's petition was filed on August 1st, 2023, Laura provided Clayton with a document she claimed was a sonogram taken in early July 2023 at a facility called Scottsdale Medical Imaging, or SMILE. The SMILE sonogram is found in the record. As part of an affidavit Laura submitted as part of the report of her medical expert, Dr. Michael Mitchell, a retired OBGYN physician who was the former chair of the OBGYN department of St. Joseph's Hospital in Phoenix. In her affidavit, Laura admitted that, in fact, the SMILE sonogram given was not created at Scottsdale Medical Imaging. Rather, Laura's affidavit explained the SMILE sonogram was taken at Planned Parenthood in California on July 2nd, 2023. Okay. In blah, 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 affidavit of Laura Owens, page 30, explaining, I did not want Clayton to know where I had gone for the appointment. To conceal that information, I modified the image to change the facility name back from Planned Parenthood to SMILE, Scottsdale Medical Imaging. And I also changed the date from July 2nd to July 7th, 2023.
As one does.
But why would you even change the date? Like, I mean, let's say we know she's not, but for argument's sake, if that's what she did or why she did it, why change the date?
Right. Because it could have been in numerous places.
Right.
Allegedly. But yeah.
Putting aside the extreme lapse in judgment that resulted in Laura providing a modified, non-authentic sonogram to Clayton, again, before this action was filed, Laura steadfastly maintained the sonogram was otherwise genuine. On that point, Laura's affidavit was clear. Other than changing the top part of the image to alter the facility name and date, I did not change any other part of the image. This image was taken at Planned Parenthood in California on July 2nd, 2023. I did not find this image online, and I did not take someone else's image and pretend it was mine. I
Except you did.
obviously regret doing this, but I made a mistake due to the amount of stress, anxiety, and depression I was experiencing. Okay.
And yet you now have felony charges for it. So, right.
Clearly, because Clayton's expert opined the only way to confirm a pregnancy was with a sonogram, Laura's testimony on this point was critical. If the sonogram was real, Laura's pregnancy was real. Of course, because Laura admitted to modifying the original sonogram to change the name from Planned Parenthood to Smile, Clayton understandably did not believe and wanted to independently verify Laura's story. There was another problem.
How does he think this is going to work for like, this is not good. This is not good. They're going to be like,
Then just go get
what?
the original photo. Okay, so
Right.
you changed it, but it's real. Then you go get the photo, right? The original photo. You have documents.
Right.
You can get those documents from your doctor. So this is not an argument to me at all. At all.
At all.
Okay. But there was another problem. According to Laura, she did not use her real name for the appointment at Planned Parenthood. Well, how do you have a freaking file if you don't give someone your name?
Right.
As a result, Planned Parenthood could not verify the sonogram was taken there. Laura's testimony on these issues was the subject of harsh cross-examination at trial by Clayton's counsel. During the colloquy, Clayton's counsel attempted to argue, using hearsay, that someone from Planned Parenthood claimed Laura's sonogram did not appear to be consistent with ultrasound images generated by their practice. Their practice, meaning a specific office in Mission Viejo, California, which is located in Orange County, California. Okay. On this point, the following trial testimony was offered by Miss Arena. And while you've indicated today that you went to Planned Parenthood under a fake name, this letter actually indicates that you had scheduled an appointment for July 2nd, but that you failed to attend. By Miss Owens, correct. It also indicates that the ultrasound image that you claimed was from Planned Parenthood was not from Planned Parenthood because it was not consistent with the ultrasound images generated by their practice, right? Not by the one in Mission Viejo, correct.
Which, how would she know that? How many Planned Parenthood have you been to in the area that you would know that for ultrasound specifically?
She has a punch card.
No, is that?
You have 12 abortions, 13th one's free. I don't know why I said that out loud. Miss Owens, these are yes or no questions. This document states that the ultrasound image you have claimed is from Planned Parenthood is not consistent with the ultrasound images generated by their practice, right? By that practice. But as they said, I could have been seen by another different entity. Miss Owens, you're well aware that this request covered all of Orange County and San Bernardino, Cal. It didn't cover Los Angeles, though. So now you're saying you went to Planned Parenthood in Los Angeles. Yes. So you're telling us you went to Planned Parenthood in Los Angeles on the day of the trial. Yes. Okay. When did you go to Planned Parenthood in Los Angeles? Exactly when I said I went. When was that? July 2nd. I thought she changed the date to July 2nd. So
well, right. But she's still agreeing that she went on July 2nd, but the one she gave to Clayton said July 7th. So
I thought she changed it to July 2nd from July 7th.
No, because she said she changed the date and the place.
Yeah, I
The
thought she
7th and
changed
the
it to July
Smile.
2nd.
Oh,
I'm
maybe
so
it was. I
confused.
don't know. My brain hurts.
I am very confused. I don't know. Dates are moving targets. Anyway, to summarize the key events prior to trial, Laura always maintained she went to Planned Parenthood in California. I'm going to answer my question. On July 2nd, 2023, I don't know, it is Gingras, so it could be totally inaccurate anyway.
Yeah.
And had a sonogram done at that time. Originally, when asked to identify the specific address of the facility she went to, Laura says she went to a location in Mission Viejo, which is a city in Orange County, California. At trial, when pressed about this claim, Laura changed her testimony and said the location she went to was actually somewhere in Los Angeles, not Mission Viejo. Why is that address change so important? Why do you ask questions and then answer your own questions?
Right. Also, I think that their appellate court's going to read that and be like, so your client changed everything, like lied twice under oath. Okay. Okay. Got it. Got it. Yikes.
How much longer do you want to go? Because
Yeah, keep going for a little bit.
okay. Why is this address change so important? Here's why.
Oh,
Unbeknownst to anyone at trial, because the business hours of Planned Parenthood were never discussed at trial, as the transcript plainly shows. After the trial ended, several of Clayton's fans conducted research, which they claim showed Planned Parenthood locations in Orange County have different office hours than those in Los Angeles. According to these online sleuths, he didn't put that in quotes. I'm disappointed.
pesky online sleuths.
Planned Parenthood locations in Orange County are open on Sundays, but offices in Los Angeles County are closed on Sundays. This information, if accurate, would appear to directly contradict Laura's claim that she went to a Planned Parenthood location in Los Angeles on July 2nd, 2023, because as the calendar shows, that day was in fact a Sunday.
Oh, David knows how to use a calendar. He's such a genius.
It's
The rest of us
impressive.
don't. I wouldn't know what day it was if the internet didn't tell me. Thank goodness we have him.
Again, when understanding this problem, it is essential to consider prior to the day of trial. Laura never said she went to Planned Parenthood in Los Angeles. She always claimed she went to Mission Viejo location in Orange County, which is okay. But what?
So you were under the impression she went there too, then, and then she changed her story on the stand, sir.
Why would you reiterate the lie
I know.
as a reason for why your appeal? Like the logic, he logics. It's not our Earth logic, I don't think.
No.
This is why Clayton's counsel rightly expressed such surprise, as we all did, and frustration at Laura's changing in testimony. So you're telling us you went to Planned Parenthood in Los Angeles on the day of trial today? Wait, on the day of trial today. I got to remember how he said it. Trial transcript page, blah, blah, blah. Prior to that moment, Laura never said anything about visiting a Planned Parenthood location in Los Angeles. But Planned Parenthood locations in Orange County are open on Sunday. So that meant Laura's testimony about going to Planned Parenthood Mission Viejo on July 2nd, 2023, a Sunday, was a non-issue until the very moment Laura's story changed at trial. Yeah.
You mean when
Okay,
she
you're
lied?
catching on. You're catching on, Gingras. You're
You
almost
lied.
there.
Mm.
So this proves several.
It's just a
key
minor
points.
misstatement, Buffy. Not a lie.
No.
Just a minor misstatement.
First, it explains why Dr. Deans was never asked about Planned Parenthood being closed on Sundays in Los Angeles. Okay, are you making their argument for them? Well, they didn't ask her because
They didn't
you
know.
lied.
Oh no.
Okay.
Yikes.
Putting aside the fact that she never claimed to have worked at Planned Parenthood in California and thus lacked personal knowledge of this point, her only work experience for Planned Parenthood was on the East Coast. Okay, because they don't probably do any of the same things
No,
or operate
never.
similarly. Okay.
For a nationally
Duh.
wide clinic? Stop. No.
Dr. Deans had no reason to discuss the business hours of Planned Parenthood in California for one very simple reason. No one in the courtroom had any idea Los Angeles Planned Parenthood locations have different business hours than those in neighboring Orange County, nor did anyone realize or mention Planned Parenthood locations in Los Angeles are closed on Sunday. That information was only discovered by Clayton's supporters who posted about it on social media after the trial ended.
Right.
And this is why it's so clear the trial judge violated Laura's rights by performing a secret, independent investigation into the facts, which included reviewing and adopting as fact statements posted on social media. I mean, was it fact? I mean, was it like inherent? Was it factual? It was obviously inherently factual. You put it in your appeal.
Yeah.
Like everyone else in court who were oblivious to the problem at the time, the trial judge could not possibly have known about the closed on Sunday issue unless she viewed social media posts after the trial was over, because those posts were the first and only instance where the issue was ever raised.
Except like, that little calendar thing that's at the bottom right of your computer screen that tells you the dates, and you can go back and forth in time to see where those
But
dates lie.
that's an independent investigation into the facts that turned out to not be facts.
Right. They weren't
Yeah.
true. She was lying right there.
While it is impossible to know exactly what websites the trial judge reviews, I want a complete Celebrite download of that judge's laptop.
They're Google everything.
Laura's notice of change of judge offered examples of social media posts made by anonymous third parties on Twitter, not the Twitter, and the website of undersigned counsel. After the trial was over, where the issue of Planned Parenthood's business hours was emphatically celebrated.
Okay.
Yeah.
So there's
Thank
one
you.
on his law site and then like one on X. So both places. Okay.
In light of this evidence, it was plainly wrong for the presiding judge to suggest Laura offered nothing but mere speculation and suspicion when alleging that Judge Mata engaged in a secret, undisclosed investigation. To be sure, because Laura asked for an evidentiary hearing on this issue, which the presiding judge denied, it is impossible to know precisely where the trial judge found the online statements claiming that all Planned Parenthood locations in Los Angeles are closed on a Sunday.
We'll never know.
Unless you get that Celebrite digital download.
But even then, that's questionable.
That does not matter. It is clear with 100% certainty that the source cited by the trial judge, Dr. Deans, never said anything about the business hours of Planned Parenthood in Los Angeles. Given that fact, and given that Clayton's fame-obsessed fans did vociferously post about this issue online hours after the trial ended,
Rabbit.
the only plausible conclusion is that the trial judge did exactly what Laura claimed. And after the trial ended, she went online and performed an undisclosed investigation into the facts. And she then tried to conceal that misconduct by falsely attributing the testimony to Dr. Dean.
God.
Oh my God, this just makes me think of the stupid investigator at the end of Clue. It's like, and she did this, or not,
In the library with the rope.
right? Like completely off base.
Yes.
In this way, by performing her own investigation into the facts, the trial judge committed structural error, which violated Laura's constitutional right to a fair trial. Or, don't lie on the stand. Or at all.
Or at all. That'd be great.
The law supporting this point was discussed extensively in Laura's motion for a new trial. In short, virtually every court that has considered a similar facts agrees when a trial judge independently investigates the facts of a case, that conduct constitutes structural error, entitling the affected party to a new trial automatically without regard to harmless error analysis. The Arizona Supreme Court embraces the same standard. In cases involving trial error, we consider whether the error so assessed was harmless beyond a reasonable doubt. If so, we uphold the verdict entered. In a limited number of cases, however, structural error occurs. In such instances, we automatically reverse the guilty verdict entered. Unlike trial errors, structural errors deprive defendants of base protections without which a trial cannot reliably serve its function as a vehicle for determination of guilt or innocence, and no punishment may be regarded as fundamentally fair.
I don't think that really happened here, but okay.
Did she get a guilty verdict? He got a verdict of non-paternity, but did she get a guilty verdict? Was there like a
No,
guilt?
'cause it was just a hearing. I don't think so.
That's what I'm saying. It's not a trial. It was a hearing.
Right. We
State
call it a trial,
versus
but it was
ring.
a hearing. So yeah, it was an evidentiary hearing, not a trial. But
Presumably, due to the high ethical standards of most Arizona jurists, comparable instances of a judge conducting an undisclosed investigation into the facts of a case and then adopting findings based on that investigation, as occurred here, are essentially non-existent. However, courts in other states applying the same constitutional standards are in unanimous agreement it is structural error requiring automatic reversal when a trial judge independently investigates the facts of a case. This is so because the bedrock of due process requirement of fairness requires that conclusions reached by the trier of fact be based upon the facts and evidence and prohibits the trier of fact from reaching conclusions based on evidence sought or obtained beyond that adduced in court.
which is why they always give the juries the same instruction. Don't read anything on the internet. Don't watch the news, yada, yada, yada.
Right. Thus, if a judge, especially in a bench trial, personally investigates the facts of a dispute or makes findings based on his or her own independent research or knowledge, rather than based on evidence admitted at trial, this conduct is a per se violation of the Due Process Clause, which constitutes structural, not harmless error.
Okay, we don't need to read that,
First,
do we?
thank you.
Okay,
No.
that's fine. And
Can
you
you
can skip
pick
that
up
forward.
here so I can go
Yes.
potty?
Yes, you go potty. Of course, judges are permitted to consider facts outside the record if those facts are proper subjects of judicial notice. However, as the American Bar Association has explained, the business hours of Planned Parenthood in July 2023 would not fall within that exception. See the bar's formal opinion explaining a judge may not use an internet search to determine hours of operation of a business, nor are business hours properly subject to judicial notice. This internet search violates Rule 2.9c of the Model Code because the restaurant's hours of operations are key to whether the plaintiff could prevail. We read about that in one of his earlier findings. When a judge ignores these most basic principles and conducts an independent investigation, the result is structural error requiring automatic reversal. You've already said this 15 times, David. This is true regardless of whether the ex parte evidence found by the judge is true, false, or completely accurate. We're not going to read all of that. Don't care. I'm trying to get us through this so we don't have to read it tomorrow. We can read funner things. Because this is painful, and I feel like we've been torturing all of you and ourselves. So, although the presiding judge attempted to minimize the misconduct of her colleague by suggesting this singular factual finding regarding the business hours of Planned Parenthood is of little to no importance given the rest of the findings in the July 17th ruling. That conclusion applied the wrong legal standard. So that's Judge Honorable Rhonda Fisk. He's saying she's wrong too. She did the wrong legal standard. It was also factually incorrect given that the issue of Planned Parenthood hours was vitally important. Was it though? Or was it your client deciding to lie and make up a new story on the stand? That seems way more important. But David doesn't want us to focus on that. Don't focus on it. This is so because harmless error analysis does not apply to structural error. Okay, so now we're in a different one. All right, great. We're not going to read all that because I don't care. For those reasons, although the court should not force the parties to waste any further time or resources on a retrial, because the safe harbor issue discussed above is dispositive, the lower court's judgment must be reversed because the trial judge committed structural error, which violated Laura's constitutional right to a fair trial. See, the award of fee sanctions under this code was plainly erroneous. Citations and record and standard of review. If the court reverses for either or both reasons set forth above, it need not reach any other arguments. However, Laura raised the trial court's erroneous award of sanctions in her motion for a new trial. As noted above, the motion for a new trial was denied by a one-line minute entry order dated September 6, 2024. That he is taking this very personally because this is like the second time he's mentioned it just in this. But I think he mentioned it in like his blogs too. As also noted above, when sanctions are challenged on factual grounds, abuse of discretion applies. However, the legal basis is challenged. Review is de novo. Whether the basis for awarding fees is proper is an issue of law that we review de novo. So just because you put in a motion doesn't, it's if you believe it to be true, though, big. Don't forget, believe. In addition to sanctioning Laura under Rule 26, the trial court also cited this code as a separate basis for a fee award. Oh, so you're saying that the judge was like, you know what? We're going to award the fees under this different law, not Rule 26 that you've been talking about for the last 64 pages. Okay. However, as Laura explained in her motion for a new trial, by its own terms, Arizona Code Statute 25 does not apply to paternity proceedings. It only applies to the costs and expenses of maintaining or defending any proceeding under this Chapter 3 or Chapter 4, Article 1 of this title. By definition, this does not include statutory paternity proceedings under Title 25, Chapter 6. The motion further explained that although the correct statute, ARS 25809G, does permit fees to be awarded where a party has engaged in unreasonable litigation conduct, and such conduct necessarily caused the other party to incur fees and costs, the facts here could not support such an award because, once again, Laura attempted to invoke the safe harbor provisions of Rule 26 by moving to dismiss her petition before the vast majority of Clayton's legal fees were incurred and before any fees were actually necessary. Oh my goodness. Hi, Winks. Oh, our brains hurt. We're doing okay, I guess. David's broke our brains today. Again, it was undisputed that both Clayton and Laura were pro se from the time the original petition was filed on August 1st, 2023, until Clayton retained counsel, who appeared in mid-December 2023. Jesus. Oh my God, David. You've already spent several pages talking. At the time, Laura moved to dismiss. In case you didn't know, he's going to remind you again. Laura had miscarried over a month earlier, and the case was set for administrative dismissal. Laura did nothing whatsoever to keep this case active once she learned she was no longer pregnant. While perhaps it would have been preferable for Laura to notify the court of her intent to dismiss sooner, the delay did not cause Clayton to incur legal fees. The case was already scheduled for dismissal due to a lack of activity before Clayton's counsel even appeared. If Clayton's counsel had done nothing, the case would have been dismissed without a single dollar of fees incurred by either side. The only reason that did not occur was Clayton's decision to file his Rule 26 motion for sanctions, which he later withdrew. For that reason, there was no factual or legal basis for an award. Okay. Because even assuming arguendo, the original filing of the petition was unreasonable. That act did not cause any fees to be incurred since the action was scheduled for dismissal before Clayton even retained counsel. So he represented himself long enough that then no. Similarly, the trial court found sanctions were justified because, quote, Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery, such that an award of attorney fees and costs is appropriate under this Arizona Code Statute 25. That holding was also incorrect in a matter of law and must be reserved. This is because, by its own terms, 25 permits sanctions when a party has presented a false claim under these sections with knowledge that the claim is false. But none of these statutory provisions applied here. 25 involves issues such as legal decision making and parenting time. It also addresses issues of domestic violence, while another one permits a court to consider that a parent has abused drugs or alcohol or have been convicted of any drug offense when making custody determinations. Clearly, there was no basis for the court to conclude that Laura knowingly presented a false claim. This was a simple paternity establishment proceeding, which unfortunately ended without the birth of any child or children. I thought it would be children because there was two, and she knew this, right? Even though there was no doctor or anything to prove that. Well, okay. Therefore, there was no basis for the court to find that Laura made a false claim under this code because none of these statutes applied here. Of course, 25 also permits sanctions if a party has violated a court order compelling disclosure or discovery. But here, there was literally no basis for the court to hold that Laura violated any order compelling discovery. Specifically, in the proceedings below, the court did grant one motion to compel, resulting in a single disclosure order. That would have been, I believe, the February 24th, 2024 hearing, where she had to like sign the HIPAA waiver or whatever. Oh, yeah, and he's going to tell us. I should have known. That order required Laura to provide 5 categories of information, but Laura fully complied with that order by disclosing all required information, which was basically nothing. Indeed, at that point, and she lied on that, right? She sent the defense to contact Mission Viejo, and then later on the stand under oath again, lied about it. Indeed, that point is demonstrated by the fact that Clayton never brought any motion seeking sanctions under 25. Had he done so, naturally, Laura would have responded with evidence proving she fully complied with every aspect of the court's discovery order. But Laura had no opportunity to offer that explanation because no motion was ever filed seeking sanctions for that code or any other authority cited in the trial court's June 17th ruling. That fact alone warrants reversal of the trial court's judgment to the extent it found sanctions were proper under those codes. The awards of fees was erroneous because the fees incurred were not necessary nor reasonable. Here, after Clayton applied for fees and costs, Laura objected. Among other things, Laura noted an award of fees was factually improper for one simple reason. Because Clayton did not incur any fees prior to the time the case was scheduled for administrative dismissal. Laura also noted the amount of fees was patently unreasonable in light of the controlling standard of ER 1.5. The trial court never expressly ruled on Laura's objection, but it was implicitly denied when the court granted Clayton's request for fees. As noted several times above, indeed several times, David, in the last 68 pages, every other line, when a fee award is challenged on factual grounds, an abuse of discretion standard applies. A court abuses its discretion when its discretion is manifestly unreasonable or exercised on untenable grounds or for untenable reasons. We're almost done, guys. Oh, we're so close. We got 5 more pages. You guys, we can do it. Can do it. Again, because this appeal may be fully resolved on other grounds, the court need not address this point, but I'm going to write about it. However, it is worth briefly explaining that even if Clayton's position was correct, and even if the trial court had the ability to sanction Laura under Rule 26 or any other legal authority, that does not mean the award of nearly $150,000 in fees was appropriate here. The simple fact remains that even if Clayton's factual allegations are true, and even if Laura was never pregnant, which she obviously disputes as vigorously as possible, the filing of Laura's petition did not cause Clayton to incur $150,000 in fees and costs. This is so because both parties were pro se during the entire period between the initial filing of the petition on August 1st and the time when Laura learned she miscarried in November 23rd. Oh my God, you were how is this a different argument? How? Yes, Jennifer. Yes. We're blatantly ignoring that she thought she miscarried before even filing it. Don't think about it. But David doesn't want you to think about it. Tay. I guess nobody told her, huh? That is the joke that keeps on giving, isn't it? Had Clayton's counsel simply picked up the phone in mid-December and asked Laura about her intentions, as Family Law Rule 9C required him to do, she would have informed him that she was no longer pregnant and there was nothing further to litigate. Again, at that point, Clayton's fees were literally $0. There is simply no legal authority of any kind to support what occurred here. Clayton asked the trial court to force Laura to involuntarily continue litigating this matter, and he then asked the court to sanction her for continuing to litigate this matter. The trial court's decision to permit this sham was clearly an abuse of discretion in every sense of the term. For that reason, even if all of Laura's other arguments are rejected, this court should still reverse the fee award in its entirety on the basis the trial court abused its discretion in both the legal and factual basis of the award.
Wait. So let me get this right.
Yes.
It was on Clayton to call and ask, not for her to disclose.
For the case she filed, yes. Yeah.
Oh, is that
It's
how that
all-
works? We're supposed to
yeah.
just call and be like, "You still pregnant? You still pregnant?" Got it.
Jennifer, yes, I do feel like it's rage baiting, very much so, because I am over it. But we're almost done, guys. We only have 3 more
has
pages.
to be. It has to be because we read Gingras' blog where he announced to the entire world that he was writing the appeal and that he was going to submit it. He's not in a rush, but it'll probably be tomorrow. But he's going to link it here so that everybody can read it. So this has to be written for JFC.
100%. 100%. All right. So lastly, Laura is entitled to fees on appeal. Pursuant to Arizona Civil, 21, Laura gives notice that she seeks an award of attorney fees incurred in this appeal pursuant to Arizona 25. In the proceedings below, Clayton committed multiple violations of the rules of family law procedure, including but not limited to filing a Rule 26 motion for sanctions, Jesus Christ, without complying with the procedural prerequisites of the rule. Of course, Clayton later withdrew his Rule 26 motion after Laura's counsel threatened to seek sanctions under Rule 26 on the basis Clayton's actions violated the rule, because Clayton invoked the safe harbor of Rule 26, Laura is not requesting sanctions against him under that rule. Nevertheless, Clayton's other conduct is more than sufficient to entitle Laura to fees under this code. Clayton continued to aggressively litigate this paternity establishment action despite knowing Laura was no longer pregnant. That fact alone was and is sufficiently unreasonable to entitle Laura to her fees on this appeal. Oh my God, you're right. Conclusion. For the reasons stated above in the last 71 pages, Laura respectfully asked this court to reverse the trial court's judgment in its entirety and remand this matter with instructions to dismiss the case with prejudice. In the alternative, Laura requests an order reversing the judgment and remanding this matter for a new trial. In either case, Laura also requests an award of fees and costs incurred in this appeal. Holy shit.
So
We did
let
it,
me get
everybody.
this straight.
There's a certificate.
Laura is entitled to fees and sanctions,
Yes.
but not Clayton
Mm-mm.
because
But
of
he-
other things he did, but not Clayton is not
Exactly.
entitled to it for other things she did. So this rule only applies. Okay.
Does it make
Right.
sense? Dear God.
Right.
Oh,
right.
thank God we don't have to read any of that garbage again. Oh my good Lord, that was awful. It's painful.
That was horrid.
Yes. Next up, not today, but tomorrow, we'll be reading the transcripts from his YouTube videos, which should be fun.
I would prefer to do that.
Right. But that puts us ahead of schedule, which I like, because that gets us closer to body cam time. So, all right, friends. Well, that is what we got for you today, because we got to check in for Karen Reed's civil trial stuff, which will just be on Couch Court with Llama. So if you haven't yet, please hop over there, subscribe, hit the notification bell. We are catching up on the civil trials. I have slideshows and everything. I read the documents, so you don't have to. Though some of them we do read because it's sassy, and we love a good sassy filing. But that's all we have for you today. We will be back tomorrow, though, at 10 a.m. Eastern for more Laura Owens coverage. Like I said, it'll be David Gingras's YouTube transcripts. So, that's going to be great. But oh my God, my brain, it's too much. It's too much. All right, Bob, anything you want to say before we go take a break and then come back in a little bit?
No.
No.
I think my brain what the
Could you
it's
imagine if he was in
broken.
the Karen Reed ones? My God.
Oh, I think
Do you think?
I don't know. I might. No, I don't. At this point, my brain is broken, and I'm literally buffering.
Buffy.
They broke me.
He always breaks
Wait,
us.
I'm buffering. No, I just. I think it might be interesting. You asked me if he was on there with Karen Reed. I actually think he might be more interesting because that actually has more substance than this bullshit.
Yeah.
So I would probably be interested in what his arguments would be on that side because there's an actual case here. You know what I'm saying? Like there's saucy on both sides over there, but I feel like there's actual substance to argue about. I'd actually like to see him arguing substance instead of the bullshit arguments that he's recycling and regurgitating and repeating and over here. Yeah, so that's my thoughts on it. He is a crap attorney, but I kind of would actually like to see his arguments if there was actual substance to the arguments. You know what I'm saying?
Right.
Like an actual case.
Yeah, it would be interesting to see for sure. Well, all right, friends, we will see you all shortly. I'm going to go straighten my hair. The humidity is like 97% here.
Oh, I'm so glad we could donate because ours is like 50, I think.
Oh, thanks. Not only did you flood my city, but now we have 9. That's why my hair is just like, it's just getting bigger and bigger.
Oh,
all right. I got to go straighten.
I feel you. I hear you. I hear you.
All right, friends. All right. We will see you later. If you want to follow us just for Karen Reed, I highly recommend it. We have playlists over on Couch Court with Llama as we've been covering it, so you can catch
The
up
True
because it is
Crime
good.
and Wine Time channel. If you're still listening over there, please go subscribe to the brand new channel. We're
Yes,
eventually
please.
going to cover low over there, and move all our content over there. It's a massive amount. At some point, it will get over there.
We're getting there.
But we're talking about Karen Reed. If you like not bullshit cases, because it's not a bullshit case, but if you like bullshit attorneys, it'll be fun over there. But this stream, the True Crime and Wine Time stream, will redirect over to the new channel, and you can kind of wait for us to come back with Karen Reed stuff if you're interested. So just
wait,
want
what
to
time
put
do
the
we
shout
have
out because
What time do we have it scheduled for? 1:30, right? So like 10
1
minutes?
or
Oh. Or is it 2? What time is it scheduled for? I don't even know.
it's 1. That's why I asked you if you wanted to end early, because it's scheduled for 1.
Oh. Well, we're gonna need like 15 minutes. I guess I won't be straightening my hair. It's fine.
No, we
It's fine.
can move it back. But that was why I asked earlier if you wanted to end it, because we were getting close.
No, it's fine. Go hang out over there. We'll be there in a little bit. So gonna take a quick potty break and whatnot, and we'll pop over there so that way we can get through some of that because there's some hearings to listen to, which are always fun. Anyway, friends, until next time, as I always say, go forth and be amazing. All right. Bye.